application.
Yes.
For injunction, my lord, that maybe for inclusion in the list, my lord. GA application, injunction
Which
application.
for the other side?
My lord, other side I've already served. Today was the date for listing it, but it is not been listed, my lord, just for inclusion.
Unless the other side is not there, how the let it be fixed tomorrow as to be mentioned. Issue notice, then I will see.
My lord, it is already been served. The first time it will be appearing for inclusion in the list.
So when is the returnable date?
Today, first time it will be moved, my lord. Is the injunction application.
Without notice.
I have already served them. They have received it.
Correct.
I filed the affidavit of
The
service
other side
tomorrow.
must know the date.
Yes, the date
So
was given
their
today.
presence only the date is to be fixed.
Okay.
Yes.
Let I have instructions to withdraw.
Withdraw.
Yes.
You have got the written instruction?
Yes.
Counsel for the petitioner has handed over a communication dated 17th August 2025, wherein the petitioner has informed the learned advocate on record of the petitioner to withdraw the petitioner that the petitioner is not intending to proceed with the matter and prays for withdrawal of the present application. In view of the communication dated 17th August 2025, learned counsel for the petitioner prays for withdrawal of AP number APCOM 374-75-2025 within bracket old number AP 717 of 2023. In view of the submission made by the counsel for the petitioner and considering the written instruction dated 17th August 2025, APCOM 375-2024 within bracket old AP number 717 of 2023 dismissed as withdrawn. Interim order, if any, stand vacated.
Number 2.
I am appearing on behalf of the defendant number 2, Your Lordship. This is appearing at my instance.
Yes.
Your Lordship was pleased to appoint the learned advocate commissioner in this matter for recording the evidence. After the examination in chief was completed, I had approached Your Lordships only for the purpose that certain documents, the mode of proving such documents are not correct, and hence it cannot be marked as an exhibit. Hence, Your Lordship was pleased to keep it today. May I hand up a compilation of all the minutes and the minutes and the deposition? The Lordship kindly comes to the 8th sitting. After the minutes, the deposition starts, Your Lordship. Kindly comes to paragraph, question number 227 onwards. Before
Yes.
Your Lordships, I come to this. May I just give Your Lordship the background of the case in a nutshell? This is with regard to the letters of credit, Your Lordship. The plaintiff is the exporter. I am the letter of credit issuing bank. I have raised discrepancies, and hence the plaintiff has filed this suit. Now, Your Lordship, from all the questions, all the documents which are sought to be proved, Your Lordship, the witness of the plaintiff has deposed. Those are lying with my negotiating bank. Beyond that, no effort has been sought to get the for the production of the originals before this honorable court.
By whom?
By the plaintiff. From the negotiating, I am for the defendant. My learned friend is appearing for the plaintiff. Their negotiating bank is holding all the documents which the witness had stated, and they have sought to prove all documents by way of secondary evidence. Now, Your Lordship, if I broadly categorize the documents, I can categorize it in two. One being the documents which emanated from the plaintiff's office or obtained from relevant authorities by the plaintiff for forwarding it in compliance of the letter of credits clauses. One. And the second is, Your Lordship, the swift messages, the letters exchanged between the LC issuing bank, the advising bank, and the negotiating bank. where the plaintiff is neither the issuer or the addressee of such document, and the plaintiff's witness has sought to prove it by stating that we have obtained a photocopy from the bank. Now, your lordship, I most humbly submit, if the secondary evidence has to be proved under the Evidence Act, first it has to be shown that it's not in their power or possession. The second, that they had sought to obtain the primary evidence which they know are lying with their negotiating bank, and then only if after all those compliances are made, the plaintiff's witness can take steps to prove by way of secondary evidence. And also, your lordship kindly notes this secondary evidence which they sought to prove, they are the witness deposed that these are the photocopies obtained from the bank.
Correct.
No document as to whether the bank has given these documents under cover of a letter, that these are the documents exchanged, communications exchanged between the banks or anything. Hence, your lordship, I am challenging the mode of proof because the documents have not been proved.
Correct.
Now the issue is, your lordship had
So that's
asked
why it
me.
has been with objection.
Yes. Now, your lordship, the issue remains. The objections can be of two types. One, the inherent admissibility of the document, where I can only raise the objection and defer it for the adjudication whether it will be marked as an exhibit or not at the final hearing. Which is why, your lordship, I am not pressing for marking for identification of the documents which emanated from the plaintiff's office or obtained by the plaintiff from the authorities. I am on the SWIFT messages and the letters between the banks where the plaintiff is neither the issuer nor an addressee nor a party to such documents.
Correct.
Because, your lordship, I am not objecting simply on the admissibility of the document, but to the mode of proof. And your lordship, I can produce, I am carrying a Supreme Court judgment where it says that if I am challenging the mode of proof, that ought to be, in the exact words of that judgment, ought to be returned immediately to the plaintiff to the party from whose custody it has come forward to the court, your lordship. Because if I am objecting to a mode of proof, that means that document can be proved only if the proper mode of proof is being proved in a proper mode of proof. And hence, I have to raise this objection and get it marked for identification now as a chance of fair play for the plaintiff to get the opportunity to prove the document in the correct manner. Now, your lordship, if this is not only these documents, if it is not decided whether it will be marked as an exhibit, your lordship, the plaintiff loses out on the fair play, so they can raise this objection at the later stage. And secondly, your lordship, my cross-examination wholly depends on that. Hence,
So what you want?
these documents to be marked for identification.
It is already there.
Your lordship,
Exhibit TTT for
yes,
the
your lordship, which I am,
objection.
because the learned commissioner does not have the power to decide whether it will be marked for identification or exhibit or subject to objection. Hence, I have approached your lordship only for marking of these documents as marked for identification.
Once
because
it has been exhibited, how this court can again?
Your lordship, under the
Sorry,
your lordship, kindly
you could have been objected. It could not have been exhibited.
Your lordship,
When
kindly-
the commissioner is going
Your
to
lordship,
exhibit exhibit
kindly-
TT,
very well, very well,
exhibit
your
SS, exhibit TT, UUVV,
lordship,
you have
kindly-
not raised the objection
Yes,
with
your
regard to
lordship, I have
marking.
raised the objection, and your lordship kindly comes to the minutes of the 9th meeting where I have specifically recorded, where it is specifically recorded before, in the presence of the counsel of the plaintiff. Your lordship kindly comes to the second page of the minutes,
Which one?
minutes of the 9th sitting, your lordship. I believe it will be the last one.
Yes.
Here. Your lordship kindly comes to the second page.
Yes.
Second paragraph. Later, the examination in chief of the plaintiff witness is complete. Mr. Dotto, learned counsel, appearing on behalf of
Where?
defendant.
Which question?
This is the minutes I am placing, your lordship, because I have recorded my objection there. Since whether a document will be marked as an exhibit or not, it rests with
Fine
your
sitting.
lordships.
Yes. Which paragraph?
The second page of the minutes, the second paragraph which starts later. The examination in chief of the plaintiff's witness is complete. so and so learned counsel appearing on behalf of the defendant number 2, which is I am, which is me, submits that he has objections regarding the marking of exhibits of certain documents.
Correct.
Hence, he intends to bring to the same to the notice of the honorable court for adjudication as to whether such documents can at all be marked as an exhibit. He further submits that only after clarification from the court he can proceed with the cross-examination of the plaintiff's witness.
Correct.
Now, your lordship, I have recorded that objection, but I cannot ask whether before the learned commissioner, I most humbly submit whether a document will be finally marked as an exhibit or not. Hence,
Sir,
at the very stage I have.
That's why again I am telling, on the last occasion also I'm telling, you have only objected with regard to the admissibility of the document.
Your lordship,
As per the record, because it has already marked as you subject to objection. What is meaning? So that is subject to proof of the document. If you are objecting the whole document, it could have been marked X for identification, Y for identification. But you are not objected, and your commissioner has exhibited the document. Now, how the court can revert that exhibit document as X for identification? Under which law? Show me.
Your lordship,
once the commissioner has given the exhibit number, how the court can revert that? You have not objected, and not one document. It is S, T, U, V, W, all the things, and you have not objected. It should not be exhibited as an exhibit S, T, U, V.
your lordship, I most humbly submit these marking of exhibits by the learned commissioner is only provisional, and it after the commission is ends.
No, that's why he has objected. Then objected, the court has to see whether it has been proved by the plaintiff or it has not been
Yes,
proved.
your lordship.
But once it has been exhibited, so court cannot say no, it cannot be exhibited. It should be X. Only the court can see, yes, this document can be treated as evidence at the time of final argument. So you have not taken objection for exhibiting the document.
I'll only submit this, your lordship. My only my liability was to raise an objection at the time of marking
objection.
And it is then for the court to decide.
The court will decide when the because it is exhibit. If you could have been come on the very first day, no, I have objected before the commissioner, but in spite of the objection, the commissioner has marked the same exhibit, so the court can restrain the commissioner not to mark X for identification. But you have slept over the matter till the examination in chief. Only subject to objection. Subject to objection is what? Subject to objection is the court has to satisfy whether the document is proved or not proved.
Yes, your lordship.
Now the court cannot revert. No, this you should become as X for identification. How the court can do?
Your lordship.
Sorry.
Your lordship.
My witness has also stepped out of the box. Examination in chief is concluded. And similar, my learned friend is not fair to the court. My learned friend should have pointed out that initially the examination took place in court. 156 documents in all have been marked. My lord, each and every document he has marked with objection. About 30 documents were examined in court. There also, my lord, same objection was taken. Only examination is to objection, nothing else.
Not raising before your lordship the document, the question
should show the initial minutes also.
With regard to the admissibility, only with the mode of proof. If I may only place one judgment, only to show, only to this aspect, that I need to raise the objection which has to be then decided. I did not.
No difficulty.
If I may only indicate this, I had raised the objection right at the end of the before starting the cross examination.
Why? Objection two types.
Yes.
One is
admissibility
of the document
and the mode of proof.
Mode of proof. So admissibility you have not denied with regard to the exhibiting, that is admitted. Whether it is proved or not, that's what subject to objection.
Your lordship,
if it is, you could have been objected admissibility of document. The document cannot be marked as X per exhibit TTTTU.
But your lordship, I most humbly submit only this much.
Not an afterthought.
Because your lordship, if I would have come to your lordships every time these documents are sought to being exhibited, that would have only slowed down the process of the before the learned commissioner. So before I started the cross-examination, when the plaintiff had the opportunity, I approached your lordships with regard to this objection. Right at the time before I started the cross-examination, and not after the cross-examination I started.
Correct. Now, during your cross-examination, the document which has been marked ABCD, during cross-examination again it will come to X for identification.
Your Lordship, not
Under which
during,
provision?
but at the time when he has completed, so that I can raise all the objections at one go.
Sorry,
Your Lordship,
when the document has been produced, at that time only you have to raise the objection, not to sleep with the total matter for the years together, and subsequently when your chance has come for examination, cross-examination, you will object for that document. You have to object the document when the document was produced before the witness.
Then your Lordship kindly envisages the situation, if I would have done that, if I have raised the objection which is clearly recorded.
Correct.
Now, if I would have come to your Lordships every time the such documents.
Not every time I have done so many matters. I have clarified the matter, how the matter document is to be
every time,
exhibited.
because
Several advocates are coming before this court mentioning the matter, how the document. This is the problem we are facing. I explain in my orders. Not in the one matter, in several matters that this court has explained how the commissioner has to, or if the objection is there, you slept over the matter, exhibited with subject to objection. You are only,
when it is
only
recorded,
with,
my
only
objection
with
is there.
Your objection is only with regard to the admissibility, subject to proof.
Mode of proof. That's
mode of proof. So
that is why your Lordship kindly
they
sees,
will not prove. They will not prove that.
Your Lordship then kindly records my submission and kindly
Nothing.
sees. Your Lordship, else my even if your Lordship, if it comes for the final
Matter
hearing,
is listed as to be mentioned on the prayer made by the counsel for the defendant number 2. Counsel for the defendant number 2 has brought the attention of this court to the proceeding 6th to the proceeding
your Lordship,
held on
8th sitting, your Lordship.
page number.
Your Lordship, the second last held on 25th June 2025, your Lordship. The second last, the last 2 meetings, your Lordship, only. Before I raise the objection. The last 2 meetings.
To the proceeding held on 25th of June 2025, wherein at the time of examination of the plaintiff witness, documents were exhibited as exhibit SS 2,
not SS, your Lordship, perhaps
SS 2
from TTTT.
Kindly see, come to the 8th sitting.
Yes, your Lordship.
226.
I am not objecting on that document.
Okay.
From TTTT.
TTTT 2.
Your Lordship, 5 A's, 6 A's. 6 A's. Of that 9th sitting, the last document.
9th sitting is different thing. First is 8th sitting appeal, which
sitting, your Lordship, the last document is
SSS 5S. 5S. And also draw the attention of this court to the 9th sitting, wherein the documents at the time of examination, the plaintiff witness documents were exhibited as exhibit 5U
to 6A's.
To 5U to 6A's. And all the documents were marked as exhibit, marks within bracket, marks as exhibit within bracket subject to objection. Cool. Now the learned counsel for the defendant number 2 submits before this court that the said documents could not have been marked for marked as exhibit. It should have been marked X for identification. X for identification, as the plaintiff has not produced any, not produced the original document and have relied upon the Xerox copy of the said documents, and the plaintiff is not the direct party to the said document.
Yes, your Lordship.
And the plaintiff is not the party to the said document.
And the mode of proof, if your Lordship can
consider the submission made by the counsel for the plaintiff, peruse the evidence of the plaintiff witness on commission. This court find that in presence of the defendant, in presence of the counsel for the defendant number 2, the plaintiff has produced the document for exhibiting, and this said documents were exhibited subject to objection. And at that point of time, the learned counsel for the defendant number 2 has not raised any objection that document should not be marked as exhibit, and the document has to be marked for identification. Now, after the document has been exhibited subject to objection, Now, this court cannot say that that's a document is to be marked X for identification. As regard the admissibility, as regard to proof of the document, this court will consider the same at the time of hearing of the matter.
And if your lordship only kindly records this,
directed to complete the examination of the plaintiff witness as early as possible. When is the date fixed?
your lordship, the date has time has just expired last week,
Today.
your lordship.
That's completing today. The time is expiring today, my lord. I don't have any other witness. This is the only witness I have.
Your lordship, 3 weeks would be enough.
By
Your lordship, kindly keeps
by
it.
29th of October 2025. Release the matter on 29th October, filing report by the commissioner.
Your lordship would be pleased to only record this, that I have approached your lordship before commencing the cross-examination.
No, your case, court cannot
Only-
make out your
only
case
this
in
much, your
order
lordship.
sheet, sir.
It
What you have
dated-
done, you have done.
Your lordship,
And not one exhibited, several exhibited, you have slept over the matter. when-
156 exhibits.
your lordship, and I'm not 156 exhibits, I'm not objecting.
Whatever it is.
Only those 2 sittings which I have
Could have been
immediately.
objected before the officer, the commissioner. You are not objected at the time of marking.
Your-
Only subject to
your
objection. What
lord-
can
your
be
lordship,
done?
the
Yes, yes, call the
recording
matter,
in the
call the matter.
minutes of the 9th meeting shows it.
Your lordship,
Wait.
in item number 3,
Grateful, my lord.
included my submissions. My learned friend was amidst his submissions. Any convenient date as per my learned friend's
What can be done?
convenience.
You persons are not appearing.
No, I was
Let it
appearing
come
all
after
throughout.
puja vacation.
I was appearing all throughout.
No, on that day nobody is appearing.
There was a matter fixed at 2 that got scuttled, and it was of roughly
My
I had
causally
minutes
after that.
causally it is mentioned. If the matter is urgent, the serious matter will be
Okay.
taken seriously.
My apologies, your lordship. I had already concluded my submissions. Any convenient date as per my learned friend's convenience.
No, I know. After puja vacation, कब है date? देखो एक date दो.
Any earlier date, your lordship, in the
Early date
next.
before vacation, there is no date, sir.
Let it run in the list, your lordship. Will take our chance.
No. Already puja after puja vacation is there. I will give one date in the after puja vacation. That court can do only.
I'll try and
Because
conclude in one.
Once the matter is called, court is sitting
Lord,
idle.
I
Nobody is
appeared.
coming.
Last order to the last order.
Yes.
I had appeared, your lordship.
By an order dated 11th of August 2025. By an order dated 11th of August 2025, this court has fixed the matter after puja vacation. Now the learned counsel for the parties praised for fixing a specific date and time. In view of the submission made by the counsel for the parties, let the matter appear on 3rd November at 3 p.m.
Very well.
I'll try and conclude in one day.
Very well.
Yes.
Petitioner for my lord, I am for the plaintiff, my lord.
Ah.
I obtain a certificate, my lord, for defendant on appeared, my lord.
Defendant not appeared.
My lord, I
And the
obtain
notice was
certificate
served.
of mode of service as per mode of service dependent served on 16 November 2024.
Hmm.
After that, they enter appearance on 4th March 2025. Mr. Miss Somi Datta, advocate, appear on behalf of the defendant.
Where is the service report?
This is the service report, my lord. After that, my lord, they have filed an application for extension of time to file written statement, which is in GA3 of 2025, but this same was dismissed for default on 4th April 2025, my lord.
Learned counsel for the plaintiff has handed over the service report dated 19 December 2024, wherein it reveals that the writ of summons was served upon the defendant on 13/11/2024 through the bailiff of this court, and on 16/11/2024 through postal services. Plaintiff counsel for the plaintiff has also relied upon the certificate issued by the Deputy Registrar Legal dated 11th of July 2025, wherein it reveals that the defendant had entered appearance on 4th of March 2025. Counsel for the plaintiff further submit that the defendant had filed an application for extension of time to file written statement, but the same was not moved, and this court has already dismissed the said application. Considering the above, let CS com 539 of 2024 within bracket CS 171 of within bracket old number 171 of 2023 be placed in the list of undependent suit. Full stop. The plaintiff is directed to file the judge's brief of document within 2 weeks. Police affidavit of evidence be filed within a week thereafter. Give the date for evidence. This is the matter on 4th November for witness action at 3 p.m. Next.
My lord, in item number 5, I appear for the plaintiff, my lord.
Yes.
There has been terms of settlement recorded between the parties.
Settled the matter.
We have settled at 13 lakhs. There was suit for recovery of money after for the
What
goods
are the
delivered.
total claim?
Total claim was 13 lakhs. Along with the interest was 13 lakhs 65,000.
Plain fine. Plain fine. You have a plaint?
Yes, sir. Well, the GA application also had the plain annex with it.
There's no prayer portion. Even GA also you're not, yes. The total claim was 13 lakhs, 89,531 along with 18%. Yes, I got it. Yes, then. So how much amount it is settled?
13 lakhs, my lord.
13 lakhs. Paid on, any amount is paid?
Yes, my lord, around 6 lakhs.
6,50,000 paid on 8th August.
On 8th August.
And other amount will be paid on 30th, 1st and okay. These are the total amount.
Yes, my lord.
Counsel for the respective parties are present. The plaintiff has filed the terms of settlement entered between the parties on
14th August 2020.
14th August 2025. It is found that the plaintiff has filed the suit claiming an amount of rupees 13,89,531 along with interest at the rate of 18% per annum from 1st May 2025 till the date of actual payment. During the pendency of the suit, the parties have settled their dispute for a total sum of rupees 13 lakhs. Out of the 13 lakh, the defendant has paid rupees 6,50,000 on 8th of August 2025 by way of RTGS. The defendant undertakes that the remaining amount, further amount of rupees 2,50,000 shall be paid on 30th September 2025, rupees 2 lakhs shall be paid, 2,50,000, first rupee, 2 lakhs on 31st of October 2025 and 2 lakhs on 15th of November 2025. Consider the submission made by the counsel for the parties, perused the terms of settlement. This court finds that there is no impediment to accept the terms of settlement entered between the parties. Accordingly, CS Com 73 of 2025 is disposed of in terms of the settlement arrived between the parties. Decree bid on accordingly. Terms of settlement dated 14th August 2025 be made part of the decree.
Much obliged, my lord.
Interim order, if any, stand vacated, or if any interlocutory applications are also disposed of.
Much obliged.
Next. Yes.
Factories outside jurisdiction.
Lord, Your Lordship, on the last occasion, Lord, allowed us to correct the plaint, Lord. This is a dispute, Lord, with respect to recovery of money, which I have, my lord, it's an admitted claim, my lord, that they wrongly got, my lord, two is the central government, my lord, floats a scheme whereby the mills, they can upgrade their machinery. So there are schemes under that, my lord. They have got money, my lord, out of two schemes, and they have admitted that, my lord, that we should not have gotten money out of those two schemes. That your lordship will find at page 147. They've admitted that. So now we are praying, my lord, for recovery of that money. Clause 12,
No,
my lord,
no arbitration.
my lord.
No arbitration clause in the scheme.
Mediation was done, my lord.
No,
it failed.
arbitration
Arbitration clause.
In the scheme there was
No, no.
arbitration.
Paragraph 2.
Yochari, dekhte cha. Let's see paragraph 2, my lord. It's the mill is outside the jurisdiction, but the registered office is within my lord's jurisdiction. So that's why clause 12. A.
The plaintiff has filed this suit for recovery of sum of rupees 9, 56, 87, 947.74 along with interest at the rate of 18% per annum. Counsel for the plaintiff submitted. Remediation process was also held, but non-starter report is filed. But matter was not settled and non-starter report has been issued by the counsel of the victim. Counsel for the plaintiff submitted. Though both the parties are within the jurisdiction of this court, but the factory of the defendant
Yes, yes.
is outside the jurisdiction of this court. And part cause of action arose within the jurisdiction of this court, and part cause of action arose outside the jurisdiction of this court. Accordingly, placed for leave under clause 12 of the latest patent. Why order to rule 2?
Order to rule 2, my lord, for abundant caution.
Counsel for the plaintiff submit that there might be a future claim
Yes.
in the suit, and as such, the plaintiff also prayed for leave under order to rule 2 of the CPC. Consider the submission made by the counsel for the plaintiff, peruse the materials on record, leave under clause 12 of the latest patent along with order to rule 2 of the CPC is granted. Plaintiff is admitted subject to scrutiny of the department. Yes.
Great.
My lord, may I just make one request before Mr. Shah starts? My lord, I'm not praying for an adjournment. I'm being led by Mr. Rai.
Yes.
My lord, he has requested me to also say he'll be 10-15 minutes late. My lord, he's engaged elsewhere. So,
Okay,
lord,
no
in case
problem.
Mr. Shah can argue, my lord, in case
I will give time to Mr. Roy, no problem. I will let Mr. Shah starts.
Very well, very well, very well. That's
Millet, we are now concerned with APCOM 91 of 2024. Millet, in APCOM 91, the prayers where, if your lordship will kindly have a look at paragraph page 16. These were essentially for sale of 32,37,045, 32 crores 37,45,000.
AP 91.
AP 91. 857, your lordship has passed an order that is under appeal. My learned friends have challenged that order in appeal. AP 91, my lord, if your lordship sees page 16, well, this is essentially for, my lord, an injunction, for an order of injunction, my lord, restraining, my lord, any further encumbrances from being created, and my lord, then, my lord, sale of the shares and direct deposit of the sale proceeds. Now, my lord, so far as this matter is concerned, my lord, the history of the matter will suggest, if your lordship will see at page 281, there was already a direction in a separate proceeding for sale of these shares and deposit of the proceeds. Page number. That's at page 221. It's in volume 3.
221.
281. Well, this was an order passed, my lord, in a separate proceeding. May I draw your lordship's attention straight away to paragraph 2 of the order. 246. Well, by this order, my lord, this honorable court well, it recorded that these shares could not be sold and ultimately directed the sale of shares. Please straightaway come to paragraph 6. On behalf of the trust, which is the respondent in the proceeding, it is contended that despite efforts, the trust has been unable to sell the shares for reasons beyond their control. Hence, the time to comply with the order dated 27 January 2017, which had directed sale of shares, be extended. And then if your lordship will kindly have a look at paragraph 9. As a last chance, the time to sell the shares in terms of the order dated 27 January 2017 stands peremptorily extended by a period of 3 months from date.
Yes.
And then, my lord, your lordship will, my lord, now turn to an order passed in this, my lord, application itself, AP 91,
This
AP
is
Com
an
90.
AP or company petition?
My lord, that was in a company petition.
Company.
But, my lord, now, my lord, it is in this AP specially, in this AP Com 91, that an order was passed on at page 238. This is an order dated 20th February 2024.
20th February 2024. Page?
Well, this is page 238. This is in volume 2.
Yes. $238.
238. Anna, I'm sorry, my lord. The page numbers will be a little different.
It is in the opposition file.
My lord, this is, my lord, since your lordship is looking at APCOM 91, this is in the affidavit in opposition that has been filed by the respondent at page 228. 228, I'm sorry, my lord. In 857, it's at 238. 228. My lord, may I just place this order very, very briefly?
228.
228, my lord.
Second one.
Of the opposition filed in APCOM 91.
Yes. Yeah, that special officer was appointed.
Yes, that's right. With a direction to sell.
Correct.
Now, my lord, then, my lord, the sale could not be carried out because of, my lord, the intervention of, my lord, the Ashika stockbroking. My lord, they filed the GA1 of 2024 in this APCOM 91.
Yes.
Now, my lord, thereafter, there was another APCOM 857 filed before your lordship, my lord, because, my lord, they were attempting to deal with the shares of Hiranmaya Energy. There, your lordship, my lord, passed an order, my lord, where your lordship recorded, my lord, the objection put forward by, my lord, Ashika.
Ashika.
My lord, that order, your lordship will find, I think is that page, well, that order will be in your lordship's records, that in APCOM 857. Well, this was passed. Well, all that we are praying now, I'll tell your lordship.
मनोतोष इसमें हो गया order रखा है देखो मैं अलग कौन order है
This is an order passed by your lordship on 16th of December 2024.
अलग thing मैं देखता नहीं इसमें order अलग रखा है
Well, this is in, my lord, a part of the reply affidavit in AP 91.
16 December?
Yes, well, 16 December, my lord, here.
Page 4, paragraph E.
My lord, we have set out, my lord, the relevant portions.
No, not. It is not sufficient to
No, just don't jump to it. I'm sorry, my lord, that is in your lordship's records, my lord, because here your lordship made a note of, my lord, what was the objection put forth by Ashika. Well, at paragraph 5 of your lordship's order, 16 December 2024. Yes. Paragraph 5. Ashika Stockbroking Limited, instead of complying with the directions contained in the order of 20th February 2024, has filed an application for vacating. And then if your lordship looks at paragraph 9.
Yes.
Mr. Anirban Ray, learned senior advocate appearing for the respondents 1 to 4 submits that in terms of the order passed by this court on 20th February 2024, respondents have provided all details to Ashika Stockbroking Limited to sell the shares, but Ashika Stockbroking Limited, one or the other reason, failed to sell the shares, due to which the respondents are not in a position to sell. So, Malad, they accept the fact that, Malad, this should be sold, but they say it's because of the objection of Ashika that it could not be sold. Then your lordship has recorded, my lord, Ashika's stand at paragraph 12. At the time of hearing, this court has called for the learned advocate appearing for Ashika Stockbroking and inquired about the compliance of the order passed by this court on 20th February 2024. And in reply, the learned advocate appearing for Ashika Stockbroking Limited submits that the respondents have not submitted the proper documents in spite of several requests, due to which the depository participant is not in a position to sell the shares of IPCL. Ashika Stockbroking Limited has filed the list of documents required on behalf of the depository participant from the respondents, wherein altogether 11 documents have been described, out of which the documents appearing in serials such and such were found in order. Documents appearing in serials 1, 3, 4 have found to have some defects, due to which Ashika Stockbroking could not be able to sell the shares. As regards document number 3, depository participant raised an objection that the board resolution for acceptance of the resignation of the erstwhile trustees was not provided. Well, then your lordship takes a very serious note of this matter, and well, here lordship ultimately records that paragraph 19. This court considered the objection raised by Ashika Stockbroking Limited and the clarification of the respondents. Altogether, 11 documents were required by the depository participant from the respondents to sell the shares of IPCL. Out of 11 documents, 3 documents were found not in order to proceed to sell the shares of IPCL. As regards the document number 1, it is found that as per SEBI circular dated 24th January 2013 for the client, which is Trust Clause Deed 5, which is applicable, then your lordship sets this out. Finally, my lord, your lordship records in paragraph 20. It is very astonished to see that the third trustee has conducted the meeting as chairman of the meeting and accepted his resignation. As per clause 6.4.1 Roman 3 of the trust deed, the number of trustees shall not be less than 3 trustees. As per minutes of meeting of the board on 8th November 2021, only 1 trustee was present before approval of 3 new trustees, and only 1 trustee has accepted the resignation of the other 2 trustees, which is in violation of clause 6.4.1 Roman 3 of the trust deed. It also appears that on 8th November 2021, the third trustee has submitted his resignation, and on the same day his resignation was accepted by new trustees, but he had chaired the same meeting as chairman. Clause 6.5.7 speaks about quorum of the meeting of Board of Trustees, and the quorum of Board of Trustees shall be in the presence of any 2 trustees. But as per the minutes of the meeting, only 1 trustee was present and accepted resignation of 2 trustees, which is not permissible. The respondents have also filed an affidavit stating that at present, the trust has 323745,165 IPCL shares, which are held in dematerialized form from the Ashika Stockbroking Limited. In the said affidavit, it is further stated that IPCL shares listed on the National Stock Exchange based on the price of the said shares for the last 12 months, the average price works out to around 21 per share, and considering the average price over the last few months and the benchmark, the total value of the IPCL shares held by the respondent 3 is around 685 crores 26 lakhs 27,823. It is further mentioned as on date the IPCL shares are valued at 17 rupees 9 paise. Then, my lord, your lordship records all of this, and finally, your lordship, my lord, records the, my lord, order passed by, my lord, the coordinate bench, which I have showed to your lordship. That is at paragraph 23.
Yes.
And then, my lord, your lordship records in paragraph 25 that, my lord, the documents are not in 25 and 26, the documents are not in conformity. And, my lord, your lordship leaves it at that so far as these shares are concerned. Your lordship passes an order and restraining herein. Now, my lord, so far as Justice Moushumi Bhattacharya's order dated 20th February is concerned, that is not in appeal. So, my lord, that order directing sale stands. We are now only asking for implementation of that order. And, my lord, apparently, even according to the respondent, the order could not be implemented because of the restriction of Ashika. Your lordship has found Ashika's objection is justified. Now, my lord, we have to find a way out because the court's order will have to be implemented. We have, my lord, made a suggestion. My lord, in our reply affidavit, if your lordship will kindly have a look at paragraph, my lord, 2E, 3E at page 4 of the reply.
In June 2020.
Well, this reply is filed on 13th June 2025.
Yes.
Well, just, my lord, one paragraph. Paragraph 3E, which your lordship will find at page 4.
Yes.
Since no appeal has been preferred from the order dated 20th February 2024, and since various unnecessary complications are being created by the respondents who are prima facie acting in concern with Ashika, just and proper that this honorable court may be pleased to direct that the signatories to the demat account of the respondent number 4 having client identification numbers, we've given that, be changed to that of the special officer already appointed, or the special officer be directed to open a new demat account with a direction upon Ashika to transfer the entire holding remaining in the demat account of the respondent number 4, maintained with Ashika, to the new account opened by the respondent 4. The idea is to sell. The respondents say it should be sold, can't sell because of Ashika's objection.
Yes.
Ashika says that it can be sold but can't sell it because respondents are not complying with the documentary directions or requirements of the SEBI. This is the reason that ultimately to wait through this difficulties that have been created, we do not know whether they are being done in concert or not. We have approached the court because ultimately it is the court's direction that has to be carried out. That is all that I have to submit in this matter.
Yes.
Yes, my lord, I just spoke to Mr. Rai. He should reach very soon, but I can start, my lord, if your lordship wishes. I'll leave it to my lord.
Ashika is the person who is objecting. They have no objection. That is recorded in your lordship's order.
Correct.
Yes.
Ashika, I have no objection if the shares can be sold. But, my lord, the prayer now made today, my lord, perhaps is beyond the purview of, my lord, the present proceeding.
Lordship's order will have to be carried out. The question is, court will have difficulties are created, court will have to find a way around.
What they are now praying for in the affidavit in reply, that's my humble submission, my lord, is slightly beyond the scope of their section 9 and also something that they are possibly not entitled to under the transaction documents.
What does that? Whether you complied with earlier directions, the three documents have been given to the Ashika?
No, my lord. Your lordship has already passed an order in that regard.
Correct.
So according to us, my lord, we had complied, but your lordship did not accept our contention.
Correct.
Your lordship had passed an order, my lord. That order is under appeal, but the appeal, I believe, has not yet been heard. So, my lord, that is one aspect of the matter where your lordship has already protected them by that same order, restraining, my lord, us from selling shares in Hiranmay, my lord, because that was the order of 16 December. Now, my lord, there was also already an earlier order of 20th February in this matter directing sale. Now, my lord, before I come to that, my lord, we'll kindly have their section 9 once. Kindly see what the scope of the section 9 is and kindly see what right they have under the security documents. My lord, since your lordship has already, my lord, pronounced on the aspect of Ashika and sale. Yes. Now, since your lordship has already, my lord, pronounced on that aspect, my lord, we are not troubling your lordship with that further for the time being. But kindly have the section 9 petition. Now, my lord, kindly see paragraph 5.
Paragraph 5
of AP 91. My lord, AP 91 is the section 9 petition, my lord, filed by Mr. Shah's client. That's the first section 9. Now, kindly have, my lord, paragraph 5.
Yes.
Page 4.
Yes.
Under the said loan agreement, the respondents had agreed to execute appropriate documents as primary security for pledging 32 lakh so-and-so numbers of shares of India Power Corporation Limited, erstwhile DPSC Limited, held and owned by the respondents along with other documents. Details of such shares are set out in a schedule. Now, my lord, kindly come to paragraph 7. While the respondents failed to create pledge of the shares as promised, subsequently the respondents had executed in favor of the petitioner herein a deed of hypothecation dated May 6, 2022, as also a deed of undertaking dated 6th May 2022, securing the said financial assistance by hypothecating charge on all the receivables, i.e. thus entire sale proceeds arising out of sale of so-and-so shares of IPCL held and owned. Copies of deed of hypothecation dated May 6 and deed of undertaking dated May 6 are annexed. My lord, I'll take your lordship to that in a moment. Now, my lord, will kindly have paragraph 9. This paragraph 9, my lord, narrates what transpired in a separate proceeding. In the meantime, the petitioner had come to learn of some orders being passed in the proceedings relating to IPCL before this honorable court, particularly in CP number 206, wherein by an order dated 7th February 2023, the respondents had been directed to sell the shares held by the respondents of IPCL. Accordingly, by a letter dated March 20, 2023, the petitioner through its advocates had called upon the respondents to deposit any and all of the sale proceeds. Now, this was a separate proceeding in relation to the scheme by which the trust was created. There was an order passed by the company court saying that you please sell. Now, my lord, kindly have, my lord, paragraph 30. Actually, my lord, kindly have paragraph 14. Thereafter, upon inquiries being made, it was learned that the respondent numbers 1, 2, 3 herein were the current trustees of the said power trust. Accordingly, under cover of a letter dated November 1, 2023, copy of letter was once again individually served. Now, kindly come straight away to paragraph 21. In between, my lord, they say that I had taken the money and had not been able to pay them back. Now, kindly have paragraph 21. From a perusal of the common loan agreement dated 15 January 2018, as also the subsequent documents, it would be evident that 32 lakh number shares of IPCL owned and held by the respondents were given by the respondents to the petitioner as the primary security to secure the aforesaid financial facility. Now, Lord, here I join issue. Lord, actually the security is different. The security is not on the shares. The security is only, my lord, to the extent of hypothecation on receivables. Now, kindly come to paragraph.
Mr. Mitra,
yes.
Once the
yes,
court passed an order, just Bhattacharya has passed an order and you have not
yes.
appealed. Now,
yes.
only the question is that how that order is to be executed. Because you have not challenged that order that has attained its finality. Now we cannot go into arguing.
I appreciate.
Correct. So, only to suggest,
no, Milord, yes.
How you can go, you will comply with that order because the special officer has categorically filed the report that you persons are not complying with the order, you're not giving all the documents which are required. So what can be done now?
Milord, the 20th February order, there's no challenge. Absolutely right. Milord, and that order says that the shares should be sold and record that we have no objection of the shares.
That is the only thing. So what
now, Milord, yes. So here, Milord, there's something that I want to say apropos what has fallen from my lord. Since the security is not on the shares, kindly appreciate this, Milord, the security is not on the shares which is admitted. The security is only on the receivables. Therefore, Milord, what they pray for now, for transferring the shares to another demat, Milord, will transfer, Milord, the entire ownership and voting rights of the shares in favor of the demat account holder.
What the 20th February 20th March order says?
That perhaps is beyond. That is why I say, kindly have the 20th, yeah, Lord, that is at page 222 of, my lord, the affidavit in opposition. Kindly have that order. My lord, please see page 223, my lord, narrates, my lord, the dues, the fact. Please see the second last paragraph. Whatever the alleged uncertainty of the assignment of loans in favor of the petitioner. Sorry, the order starts at 222. Kindly have 223, second last paragraph.
Correct.
Whatever be the alleged uncertainty of the assignment of the loans in favor of the petitioner, it is clear that the respondents owe a substantial amount of money to the petitioner. The amount is presently 633 crores. The letter written on behalf of the respondents does not dispute the fact of the loan. The only difficulty appears to be the depository participant, One Ashika Stockbroking Limited, which is resisting the sale of shares of IPCL in Power Trust. The court takes note of the submission made on behalf of the respondent that 633 crores is an inflated amount. Hence, this court is of the view that a special officer may be appointed to oversee the sale of shares upon appropriate directions on the depository participant. The order shall be in the form of an interim protection Subject to the fate of the arbitration petition, Mr. Munish Roy of the Bar Library Club is appointed to take appropriate steps. So, my lord, two things are very clear from this order. One is, my lord, this was an interim, my lord, protection subject to final hearing. This was at the ad interim stage. Now, my lord, we are on affidavits.
Correct.
Number two, my lord, the direction was to issue directions on the depository participant for the purpose of, my lord, selling the shares. Not for the purpose of, my lord, appropriating the shares, not for the purpose of, my lord, transferring the shares to another demat account.
Yes.
The direction is, my lord, for sale of shares. So, my lord, this order does not help the petitioner to assert any title or right over the shares or to claim transfer to a demat account. This says that sale has to be facilitated.
Correct.
Now, my lord, also on 16th of December 2024, kindly have that order once more, my lord. My learned friend has also read out a portion of that order. Kindly have that once more. Please see your lordship's order of 16th, my lord, December. Please. Just kindly give me a moment, my lord. I have seemed to have misplaced that order. Lord, kindly give me one moment. Lord. This is the problem with electronic. Yes. Now, in your lordship's order, kindly come to, my lord, the discussion where your lordship has passed directions on the shares. Please see paragraph 25.
Yes.
This court finds that since the year 2017, this court directed to sale of so-and-so shares of IPCL, but till date the sale is not done. This court, by an order dated 20th February 24, appointed special officer for sale of shares, but the respondents are not providing required documents to the depository participant, due to which the depository participant is not in a position to sell the shares. The documents provided by the respondents to the depository participant clearly reveals that the said documents are not in conformity of SEBI circular and in violation of several clauses of trust deed. Considering the above, this court finds that the petitioner has made out prima facie case and balance of convenience and inconvenience is in favor of the petitioner. Accordingly, the respondents are restrained from dealing with or encumbering or diluting their shareholding and shareholding of Power Trust in Hiranmaya Energy till 10th January 25. This order has been extended and direction was given for filing of affidavits. So, my lord, two things again become clear. Your lordships had considered the 20th February order. This was passed in their second section 9. My lord, the first section 9, which is what I was placing, kindly have volume 1 once more, my lord, of that. Please see the prayers that they have sought in the first section 9, on which the 20th February order was passed at the ad interim stage. And my lord, here, my lord, at the ad interim stage, my lord, since we are at the final stage on affidavits, my lord, please have, my lord, page 10. My lord, I'd like to show some of the pleadings that they had made, because this is important so far as the scope of the section 9 is concerned. Kindly permit me just to, my lord, complete it.
857 pleadings have been completed.
Yes, my lord.
Pleadings have
Yes, my lord, 857.
That's why you have filed an appeal.
Yes.
If I tell that the 857 will be taken up for hearing, both applications will be taken up together and matter can be heard up. Otherwise, you file an appeal, it is very difficult to this court to decide that.
Well, I filed an appeal, but it's becoming very difficult to get it.
So that is the problem.
That
So
is
I
not your
cannot,
lordship's problem,
this court
obviously.
cannot dispose of.
Well, your lordship, well, I
If,
can
if
only,
both the parties give consent, I will take both the 851 and 91 together.
if
and
my learned
dispose
friend
of.
consents, I have no.
That's why. If
But
you
the
give the consent,
difficulty,
because now you are taking the benefit of this.
no, well, the difficulty your lordship might recall, it is not a part of the affidavits, but we had handed up to your lordship resolution, my lord, on the part of my lord IPCL to transfer their entire unregulated business to a third entity, which is its subsidiary. My lord, those documents were handed up to the court, my lord, without affidavits.
So
And
that's
my lord,
why that will be.
then the value of the shares will completely come
There
down.
will be a conflict of the decision. If you take instruction, if you want that the 857 be argued on merit, the 91 and 857 be taken together and it
But
can
the
be
only
disposed.
problem, only difficulty would kindly, my lord.
No, tell me.
Difficulty would be, my lord, if I say today that I'm conceding to this to being heard, or my lord, I will have to concede to that order of 8, which is under challenge.
No,
And
my
we are
lord, this
primarily
is
fine.
you
That
get
is
the
an addendum.
are
I'm
you
trying to that.
or Mr. Ray?
I understand, my
cannot
lord.
suggest you
I
get the
obviously, my lord, I'm not
you get the dispose up that will not affect in the final hearing. That's all.
That's an ad interim order.
Yes,
This is a
that's the ad interim order. Get the dispose up with the 2 lines order that will be not affecting the final disposal automatically. That even there is a automatically.
Absolutely, absolutely.
You take then both the matter
Well,
can
I'll
be
do that,
disposed of.
because we have been trying, my lord. It has been doing the rounds. Because everyone is releasing. That's the problem with this matter. No, that can be, this order can be obtained on a mere mentioning.
Yeah, that's
We do that, my lord. It's
if
before
you're
the court room
ready
number
to
4, my
argue,
lord,
so
we try and do
this
that.
court can take both the application together, so future complications should not
Definitely,
be
madam.
there.
But I appreciate
Whatever
that.
either here or there, the matter has to be disposed of.
Yes, my lord. But my only request is, my lord, this has to, my lord, we have been troubling your lordship because, my lord, of the apprehension that once the unregulated business is transferred, then, my lord, the share value will plummet. That has got nothing to do with this application. That will be my first submission. My lord, this is not the way, my lord, we do matters before your lordship.
No.
We can't give effect to that.
That's why I'm appreciating.
Well, lordship will ignore that.
What he's
I
saying
am only
about the new
pressing that.
apprehension,
That's not on record. My lord, let it, my lord, be ignored for the time being. I am, my lord, pressing for the hearing of this application because I perceive that there's an urgency. That is all. Lordship will kindly not take this on into account for the time. That is the best thing, my lord. My lord, otherwise, when I'm ready, my lord, because it fell from your lordship that there might be some. My lord, let us we'll try and dispose it of. My lord, gives me 10 days.
That is the ad interim order.
Ad interim, my lord, so it wouldn't affect,
What
my
will
lord, as
happen in the appellate? Appellate will not dispose of in
I also believe in that, but to go and say that I'm not pressing it, well, might become a bit of a
not
problem.
pressing, but
If your lordship feels that it's an ad interim, it will not have any effect in the final ballot, which it shouldn't have.
But your appeal is here.
I know that, my lord, that is the technical problem, my lord.
Your
Otherwise,
appeal
my
is
lord,
there.
prima facie observation, your lordships are also not swayed by your lordship's observations, obviously. my
That is the prima facie.
I also appreciate that. But
direct-
since it fell from your lordship, my lord, that is why I am a bit now concerned that we will have to go and get the appeal disposed of, saying that, my lord, it will be finally heard out by your lordship, my lord. Well, let me take instruction, my lord, keeps it after 7. No, my lord, this instruction will not take any time. My lord, this is only a matter of 1 minute. If my learned friend come and say that, that's a different thing. But we will go and immediately concede before the Court of Appeal that, my lord, that will not, my lord, prejudice the hearing of the application.
This is the prima facie.
Not only that much, I suppose we need that.
Suppose, see, if you could not even challenge that, the court cannot say.
I'm not worried about this.
That I pass
Yes.
an order that I cannot change that, because that is a prima facie view. After the affidavits, we can do whatever it is.
My lord, I'll be very open to your lordship, my lord. It is not with regard to this matter that I'm worried about. My lord, that matter observation, my lord, will have effect in certain suits which I have pursued against them. That is my problem, my lord. Well, that
So
appeal can go on, my lord, independently. That will not
Okay,
hold
then-
up the final
then
hearing
it
of
has
this
to be
matter.
disposed of.
We can also
91 is to be disposed of
That's right.
separately.
I
Nothing.
will do it. Whatever happens to the appeal will happen if your lordship, and we are all aware of that, man. It's a prima facie finding, but your lordship will hear it out. Hear this out, my lord. Let it. The affidavits are complete in this matter. Your lordship will hear it.
Affidavit is
So, my lord, I hope Mr. Shah has completed his argument. Then, my lord, we can.
91.
Yes, I have completed. Let my learned friend
Sir,
respond. I shall, my lord, argue.
91.
Thank
So, Mr. Mitra has started
Well, I know.
on your behalf.
I'm sorry, my lord.
No, not problem. There is no
Whatever.
problem.
But I even stopped appearing online from the cars, my lord. I was not aware that such an order has been passed by the Punjab. And, my lord, I appeared in another court, my lord. That court took major exception. And I wasn't even aware. And I was, what did I do wrong? Then I realized someone told me. I said, I'm so sorry. I was not aware of this. And that's why I'm not taking a chance, my lord.
कल रखा है क्या? 6 minutes.
Huh. Very shocking.
So now Mr. Shah has completed.
Yes.
Come on 21st. Come on 21st. In the meantime, if you take instruction, if it's that, then both the matter can be
in only one thing, my lord, since my learned friend is here, my lord, 8:57, the interim order was till tomorrow, 19th August.
I'm extending this.
Yes, 8:57.
Learned Counsel for the petitioner in APCOM 1991, 19/1 of 2024 has concluded his argument. Police. Due to paucity of time, and learned counsel for the respondents also argued the matter for some time, but due to paucity of time, hearing could not be completed. Accordingly, it is adjourned. Let the matter appear on 21st of August under the same heading. Under the same heading. Full stop. Ab dusra 857. Item number 857. Learned counsel for the petitioner submitted. The interim order is up till
19th August.
19th of August 2025 and place for action on interim order. In view of the submission made by the council, the interim order is extended till 27th of August 2025 or until further order.
21st will come.
Let both the matter appear on 21st.
Grateful. Grateful.
Yeah, hearing it. Yes.
May I please, your lord. I was arguing the plaint, I was showing the plaint. I'll just refresh your lordship that 3 floors were given on rent by the plaintiff. Unlike in the previous matter, it was IPCL. Here, the plaintiff is ICPL. So the property is situated at 163 SP Mukherjee Road, a very valuable property in the South Kolkata. The defendant had taken it on lease by way of a registered lease, and a service agreement was entered upon. There was a lock-in period of 36 months. The registered agreement was 11th October 2018. And because of the COVID, defendant being an NBFC, they chose not to operate from the space and they left the space. So the entire dispute is with regard to the residual rent of the lock-in period and also few months of rent which was pending. Most of the documents, in fact, except one, certain invoices, all the documents are admitted by the defendant. Defendant chose not to adduce any evidence, the witness.
Who is the defendant?
Defendant, earlier Mr. Huda was appearing. Thereafter, on the last occasion, one lady appeared, said that they have taken change. But your lordship granted them to file wakalatnama, which I don't presume they have filed.
Okay.
So, I was just, this was the background. So, I was showing your lordship the plaint. In fact, on the last occasion, it was very briefly I argued, then your lordship was, because of the time, paucity of time. May I start from paragraph 4?
Yes.
Sometime in or about 2017, the defendant approached the plaintiff number 1 for taking, there were 2 plaintiffs. One is the one who is owning the property, and the plaintiff number 2 is the company under the plaintiff number 1 which provided the services. And
in whose name the property is?
Plaintiff number 1. The claims are from both. The plaintiff number 1 for taking a commercial lease for the purpose of carrying out its trade or commerce in Kolkata, and discussions were held between the parties. The plaintiffs offered inspection of a portion of the office space available at Thapar House at 163 SP Mukherjee Road, and the same was inspected by the defendant, and defendant was agreeable to take on the lease the 3rd, 5th and 6th floor of the said building at the said premises.
Yes.
The defendant represented that it required some special fit-outs and equipments installed in the premises before the commencement of the proposed lease, and it was agreed between the parties that the plaintiff number 2 would provide the required fit-outs and equipment and also all necessary services to the defendant for the said office space, and that the plaintiff number 1 would execute a lease in favor of the defendant. Accordingly, the plaintiff number 1 entered into an agreement on January 10, 2018 with the defendant for leasing out the office space at Thapar House at 163 SP Mukherjee Road, measuring 6644 square feet and situated on 3rd, 5th and 6th floor of the said building. As agreed, the plaintiff number 2 and the defendant entered into an agreement dated January 10, 2018, being the service agreement for facilities, amenities and fit-outs. Now the relevant clause of clause 8. The said service agreement provided inter alia the following clause. The plaintiff number 2 is described as the service provider and defendant as the client. Clause 2. That it is expressly agreed between the parties here too that so long as client is using the premises, it shall avail and bound to use the services of the service provider, and in no eventuality the client will have the right to determine the agreement with the service provider while continuing to use the premises. It is expressly understood by the client that the service provider has made special provisions and incurred expenditure for the services to be rendered under this service agreement, and if client terminates this service agreement or ceases to use the services of the service provider while continuing to use the premises, the client will be liable to pay all the payments to the service provider under parts 1, 2, and 3 of this service agreement for the period during which it continues to use the premises. Clause 3. The service agreement held between the client and the service provider is coterminous with the lease deed and will automatically come to an end once client's right to use the premises comes to an end, or upon handing over the physical possession of the premises to lessor, or upon expiry of the lease period or early termination of the lease deed. Clause 8. All such payments shall be at actuals and shall be made by the client directly to the service providers within the time specified in the utility bills of service provider upon being provided the bills for any of the aforesaid utilities, electricity or other charges. The client shall be responsible to bear and pay all interest penalty payable to such service provider in the event of failure or delay on the part of the client to make timely payment thereof, provided that the service provider has handed over the utility bills to the client and only for the period after receipt of such bills from the service provider, as the case may be. In the event such payment is to be made either to the service provider as a reimbursement, then in the event of failure or delay by the client to make the payment to the service provider, as the case may be, within a period of 21 days of valid invoice being received by the client, the outstanding amount shall bear and carry interest at the rate of 12% per annum from the date of such demand and was made upon the client till the date of realization thereof by the service provider, as the case may be. Clause 12. The service
these are the conditions.
These are the conditions, Your Lordship. So now clause, if Your Lordship kindly takes page 7, clause 7 is very important. Page 7, clause 35.
Yes.
The client shall simultaneously with signing of this service agreement provide the service provider with detailed drawing, design, charts, layout for fit-outs of the demised premises. The service provider has, on the basis of mutual discussion with the client, stipulated that an amount of 96,14,384 shall be incurred towards carrying out the fit-outs in demised premises. The said amount of 96,14,384 shall be recovered by the service provider from the client in the form of monthly rentals, fit-out rentals, at rupees 22.32 per square feet, amounting to rupees 1,48,317. So the purpose of this clause is that the fit outs are customized. So I can't make those fit outs handed over to subsequent any lessee, because whoever will come will have it as per their convenience. So whatever is made, it's for the specific purpose of the defendant. And if the defendant, that's why the lock-in period, if the defendant doesn't use it, he has to bear the entire cost.
Correct.
In fact, clause 37 also says that the fit-out rental shall be paid continuously for 105 months. Para 10 at page 9. The plaintiff number 2 duly carried out the required fit-out at the said premises, and the defendant took physical possession of the premises on October 11, 2018. On November 2, 2018, the plaintiff number 1 entered into a formal registered deed of lease with the defendant in respect of the said premises. And the said lease has superseded all earlier agreements and understanding entered into prior thereto. The deed of lease also had the clauses that for a period of 9 years from 11th October, subject to payment of lease, that was the tenure of the lease, and 36 months was the lock-in period. Clause 2.1 provided the lessee shall pay lease rent at the rate of rupees 52 per square feet per month, that is rupees 3,45,488 per month, payable by 15th of each, and shall carry interest at the rate of 12%. So the interest was also agreed at the rate of 12% for both the lease as also the rentals for the service agreement.
So first is the 9 year.
9 year is the entire tenure.
October 2018.
Lordship.
And second clause.
No, 9 years from 2nd November. 11th October, I handed over them the possession, but the agreement was entered upon on 2nd November because 1 month they took for the setting out and the fit outs.
Okay, whatever it may be. But here it is recorded 9 year from
9 years. Sorry, 9 year from 11th October.
11th October. And provide the lease result 52 rupees per square
feet.
That is rupees 3,44,5,000.
Lordship.
And where is the increase?
Your Lordship,
carry in 15th of every month interest at the rate of per annum due to the date of within 15
15 days.
12% will be interest.
Lordship.
Okay, then
Then there was the locking period.
The locking period of 36 months.
Lordship. And there's a security deposit of 20 lakh 72,000 which has been paid.
Yes, no problem. Then the valid is October 2017. Subject to lock in the period, agreement terminated.
And the lessor was not entitled to terminate the agreement, subject to there has been, and the lessee shall pay all areas, if any, and unpaid rent.
Correct.
Now, para 13, here when the disputes.
Yes.
After taking the possession of the said premises, defendant commenced business therefrom. Defendant was making payments of 3,45,000 per month on account of lease rental and was paying service charge as per service agreement at the rate of 79,728 per month. Defendant continued to make payment up to December 2019 and thereafter suddenly stopped making payments to either of the plaintiffs, both the plaintiff number 1 and 2. Several reminders were sent. Since March 25, 2020, due to the worldwide pandemic, due to the coronavirus.
Where from you're reading?
Para 15, Your Lordship.
Yes.
Since March 25, 2020, due to the worldwide pandemic, the coronavirus, the government of India declared a national lockdown and various steps were taken in this connection as stated hereunder. So the plaintiffs following the government protocol restricted entry to the said building and only persons with proper gate pass were permitted. Defendant continued to remain in possession of the said office space and its operations thereat. It is pertinent to note that non-banking finance businesses come within the meaning of emergency services and were permitted to continue business during the locking period. On or about 19th May 2020, defendant sent an email to the plaintiffs wherein they proposed to recommence their office from 22nd May 2020 and indicated that they will share the name of the employees by 21st May 2020. Plaintiff requested for the names of the employees for issuance of gate passes. Thereafter, the defendant sent a list of the employees against which the entry passes were to be issued. During the period May 22 and 29, the officials and the staffs were taking out large stacks of documents and papers from the business premises and appeared to be making arrangements for moving out of the premises. Plaintiff immediately engaged in a discussion with the defendant regarding its intention and requested the defendant to make payments for its outstanding dues, which were at that point of time pending since December. By an email of May 26, 2020, the plaintiffs reminded the defendant of the terms of the lease and particularly clause 3, whereof it provided for a lock-in period of 36 months. And in case of an early termination, the defendant was liable to pay the lease rent for the unexpired lock-in period. Plaintiff also reminded the defendant of his liability to pay interest at the rate of 12%. By an email dated May 30, 2020, the defendant informed the plaintiff number 1 that it was terminating the lease owing to force majeure. It referred to the national lockdown imposed by the government order owing to the pandemic, and it stated they were unable to access the properties and alleged that the payment of rent stood suspended on and from March 24, 2020, since the force majeure event has subsisted for more than 15 working days. It also alleged that it had resumed operations from May 22, 2020 and obtained entry passes from the plaintiff, but allegedly could not commence work and only a handful of staff visited the office to collect certain paper and documents. It alleged that the force majeure event having exceeded 30 working days, wherein it had been prevented and unable to access the properties, it had exercised its rights under the lease and forthwith terminated the lease in terms of the clause 14 of the lease. It also alleged that the plaintiffs have not been able to perform the obligations on the service agreement from March 24, 2020, and since the agreements were coterminous, the service agreements also were being terminated. It contended clause 3 was inapplicable and did not survive, and finally alleged that after adjusting the outstanding in respect of rent, a sum of rupees 34,548 up to May 31, 2020 would be refundable to the defendant out of the security deposit. They said you adjust from the security deposit and only 34,000 remains, which the plaintiff ought to have given. By an email dated June 5, 2020, plaintiffs immediately replied to the mail, reiterating the legal point that the termination was illegal and the defense of the force majeure cannot be raised, and the defendant was in possession of the lease premises and also recommenced its office. Thereafter, the defendant, upon receiving such mail, started falsely alleging that its staff members were not being allowed to take out goods from the premises. Even though the defendant and his officers and staff members had taken out all documents and other materials from the period of May 22, 2020 to May 29, 2020. And the plaintiffs were apprehending that the defendant was trying to enter the premises to remove the fit-out materials which the plaintiff number 2 had installed on its own. On 10th June 2020, plaintiff issued an email clarifying its stance that in light of the impending threat of destruction of fit-out equipment, it had decided to discontinue any further movement of defendant staff members. Thereafter, the defendant started lodging false complaints before the local police station regarding ingress and egress of the said premises. Various correspondence were exchanged between the parties regarding the same, since the plaintiffs apprehended that the defendant was trying to wrongfully remove the fit-outs belonging to the plaintiff number 2. Thereafter, the defendant eventually approached the High Court at Calcutta by way of a writ petition being WP number 6620W of 2020, alleging that the police were not helping it. In the writ petition, this defendant categorically mentioned that it was carrying on business from 9B Wood Street. And by an order dated September 15, the Honorable High Court was pleased to dispose of the writ petition by holding that the parties are at liberty to approach the civil court for their relief. Thereafter, by an email of September 29, plaintiffs offered to return the goods, and by an email of October 1, 2020, the defendant agreed to take back the goods. Para 16. And on October 5, 2020, defendant handed over the said premises to the plaintiff as recorded in the letter dated October 5, 2020.
So October 5 he has handed over.
Till October 5, they were in possession. This is an admitted position. But the plaintiff also have a claim with regard to the residue period of the lock-in period. The 3 years, which started from 11th October 2018. So it's an undisputed fact that the defendant terminated the 2 agreements which were coterminous on May 30, 2020 and was in wrongful possession of the property since May 31, 2020 till October 5, 2020. The said premises comprise of large 6644 square feet office and commercial space, and present market rental of the same would be in excess of rupees
1.75 per square foot.
I think it should be 175 because the lease says of 52. As such, the plaintiff number 1 is entitled to mean profits in respect of the said premises at the rate of rupees 175 per square feet per day from May 31, 2020 till the possession of the premises is handed over. Such rate is reasonable. It is a commercial property situated in the heart of Kolkata together with the interest. The value of the mean profit for 128 days is rupees 14,88,256. Alternatively, this honorable court may hold an inquiry into the quantum.
You calculated also 1.75.
I think there is some.
Your calculator also 1.75.
It should have been 175. Then be that whatever is there in the plaint, I can't improve on it. Now, because of these dates, if your lordship may, the plaintiff at para 23 is the claims. In these circumstances, there is now due and owing by the defendant to the plaintiff number 1 a sum of rupees 89,57,896 as per the following particulars. Lease rent from January 2020 to May 2020, which is 20,38,000. Interest at the rate of 12% per annum, which is another 1,53,000. Mean profits from 31st May to 5th October, which is 17,56,000. Interest at the rate of 12%, 51,728, and liquidated damages as per the lock-in period violation, that is 49,57,000, totaling to 89,57,896, and a further interest of 12%. And if your lordship comes to para 28, a sum of rupees 1,28,46,947 is due to the plaintiff number 2 for the service agreement. Outstanding dues till 31st December 2019, which is 9,04,617. Interest on that, which is 1,05,000. Then outstanding service rentals, which is another 9,10,074. Interest on that, which is 68,838. Unpaid installments under clause 39, which is 8,75,070. Interest at the rate of 12%, and balance fit-out payments under clause 39, which is 99,17,437, totaling to 128,46,947.
Yes.
So these are the claims of the defendant. Now, defendant has not disputed any of the plaintiff's documents, save and except the invoices there was a commissioner, learned commissioner appointed for taking down the witnesses of both the two witnesses of the plaintiff. One was for the plaintiff number 1 and another was for the plaintiff number 2. All the documents were produced and exhibited. If your lordship takes the commissioner's report, the details of the exhibits given by both the plaintiff number 1 and plaintiff's witness number 2 are there at page 18 and 19 of the report.
They were cross-examined?
No, they were cross-examined, but defendant thereafter never appeared, never gave evidence. It was on the day 1 their witness came for examination, if your lordship recalls. Then suddenly after the day 1, he went back and he had a ankle sprain and he left for Mumbai, but he couldn't come for the commissioning. So their evidence was closed. No order was, no challenge was made to that order, and they have accepted.
Yes.
So these are the documents which are marked in this report at page 18 and 19, which are the documents. And if your lordship also has a look at the affidavit of admission denial by the defendant, all these documents are admitted except the invoices. The invoices are also exhibited. I'll just, that is at original affidavit. Serial number 6, exhibit F. So that was only thing which was not admitted, that is also exhibited.
Okay.
So all these are part of the judge's brief. Now the important fact is the defendant has admitted that it's an NBFC company. Their only ground is the COVID. Now, only thing which your lordship, I'll request your lordship to adjudicate, whether the defendant can take the ground of the COVID, being an NBFC, and having chosen not to operate its office function from the office premises, the suit premises, can they take the benefit of the COVID as a force majeure? That's the only short point involved. So, may I take your lordship through the judge's brief of documents for the exhibits?
Yes, no, when the 11th October
2018 is the position they have taken.
11th October 2018 position taken.
Rent pay agreement was of November 2, 2018. The lease agreement. Lease agreement was November 2, 2018.
2nd November.
2nd November.
But it starts from 11th.
11th. They handed over possession back on October 5, 2020.
No, so 36 months your locking period, 36 months is?
It ends on 10th of October 2021.
10th October 2021. Locking period.
Locking period.
And he left vacated premises?
They terminated on May 2020, 31st May 2020.
21st?
May 2020 they terminated, but they were in possession till 5th October 2020 when they finally handed over the possession.
Agreement terminated?
They terminated on citing the grounds of force majeure, that because of the COVID pandemic they cannot operate, so they are terminating the agreement.
And vacated?
They vacated on 5th October 2020. I'll hand over a short list of dates along with the notes once I finish for your.
They are vacated. So we are, as if it is termination, so before the 36 months, here they are terminated.
No, they cannot terminate because of the lock-in period. That was the.
And vacated within the lock-in period.
They vacated within the lock-in period on October 2020 because I had another 1 year.
So if the 36 months is taken into consideration locking period, so they are in, you are entitled to get the rent till October 2021.
2021.
That is the one.
That is the, I'm entitled to get the lease rental as well as the service rental.
When they have stopped paying rent?
January 2019 was the, December 2019 was the last payment received from them. With regard to lease rental and with regard to service rental.
Lease rent when, till which month they have paid?
December 2019.
December 2019. December 2019.
Lordship. And
the maintenance charges?
Service was, it was due till 2019 was 9,04,000. Till 31st December 2019, there was a due of 9,04,000.
31st December 2019.
Yes, there was already a due of 9,04,000, area due.
9 lakh?
4,617. That is mentioned in para 28 of the plaint.
Okay. Okay. So the question is, when now they have taken the force majeure.
Lordship. Now, if a lordship takes the email, I'm showing it from the plaint itself. One very important email is at page 113. This is a mail of 10th June 2020, which is after their termination. I'll also show the termination mail.
113.
10 June 113. This is from one Mr. Sunita Mukesh Kumar Singh, RCF, that is Reliance Commercial, which is the defendant. Sunita Singh. Dear Mr. Saxena.
Yes.
Dear Mr. Saxena, it is absolutely wrong on your part to obstruct us from shifting our documents. Please note that you do not have any locus standi to do so. We as an NBFC need to file compliances from time to time with RBI, and any failure to file any compliance on account, your high-handed behavior shall not be appreciated at all, and you shall be solely responsible for the cost and consequences. So here they themselves admit that they are an NBFC, and NBFC was part of the emergency services, which was outside the purview of the government guidelines in COVID.
So this has been given by the defendant.
This has been issued by the defendant itself.
Sunita
Singh. If your lordship takes, and though it's very shortly, Sunita Singh / RCF and / RHF.
Yes, yes.
Reliance Commercial Finance and Reliance Home Finance.
Yes.
Now, if your lordship takes the page 104, that is the termination.
104.
Your lordship. I'll just read it because it's very shortly typed. It's addressed to Indian City Properties, that is the plaintiff. Subject, lease date dated 2nd November 2018 in respect of property at Thapar House, 163 SP Mukherjee Road, Kolkata, 7,26,000. Termination owing to force majeure. We refer to the caption property. As you are aware, we have been in discussion with you over the past few months. As you are aware, owing to the pandemic and the government order imposing a nationwide lockdown on and from 24th March 2020, we have been unable to access the caption lease property. In terms of the lease deed, the payment of the rent has stood suspended on and from 24th March 2020 since the force majeure event has subsisted for more than 15 working days. As you're aware that although we had resumed operations from May 22, 2020 and had obtained entry pass from you, yet could not be commenced, and only handful of the staff visited under the lease deed and forthwith visited the office to collect certain papers and documents. Given the pandemic, work has not started. In fact, the force majeure event now having exceeded 30 working days, wherein we have been prevented and have been unable to access the caption property, we exercise our rights under the lease deed and forthwith terminate the lease dated 2nd November 2018 in terms of clause 34 of the lease deed.
Yes.
As you are aware, the force majeure event is such that it is also preventing us from removing our belongings and properties from the leased property at the present moment, so that physical possession thereof can be handed back to you. We assure you that once the force majeure event comes to an end, we shall, within a period of 15 working days, hand over the possession of the leased property to you in terms of the lease deed.
How this force majeure they have calculated?
They are saying that from 24th March, when the government gave the notification, that is the date of the force majeure.
In your agreement, there is some clause
No,
of force majeure.
there is a clause of force majeure, but that is not with regard to the pandemic. Force majeure,
what is the
lordship, I'll just
force majeure clause in the agreement?
November 2 is at page Annexure C, page 50 of the plaint. Clause 14, 69.
Yes.
If during the term of the agreement, the lease is unable to have, the lessee is unable to have access to or make use of the lease premises due to any force majeure event, such as national emergency, riot, general strike, war, fire,
Natural
flood, natural catastrophe, earthquake, terrorism, or if such force majeure event causes loss to and or damages the lease premises, in case the force majeure event continues beyond a period of 15 working days, the obligations of the lessee to the pay compensation to the lessor under the agreement shall be suspended. However, if such force majeure event ceases or comes to an end during the lease term, then the obligations of the lessee shall come back into effect immediately. If such an event persists for a period longer than 30 working days, this agreement shall stand terminated at the sole option of the lessee at the expiry of 30 working days, and in which case the consequences of termination shall immediately follow. So they are trying to take benefit of this word national emergency. Defendant being an NBFC, and this COVID, your lordship, the banks were open, the NBFCs were open, all the emergency services were open. And it was phase wise, the government has also lifted their relaxed the lockdown rules. They cannot take this benefit. There are judgments also on similar grounds passed by Delhi High Court. Unfortunately, I couldn't find one from Calcutta High Court, but Delhi High Court also has, in a similar situation, said that the defendant being a NBFC cannot take the benefit of the lockdown imposed by the government. It was a nationwide lockdown, definitely, but it was not applicable to the persons giving emergency services to the public at large.
In that, the force majeure clause was there.
Lordship?
The Delhi High Court cases, the force majeure
clause was there. There also the defendant tried to take the benefit of the force majeure. There was also money claim.
What are the document or the evidence you had you that even though during this COVID period they had the business and they are continuing with the business?
Your lordship, admittedly, they continue to have the position.
Possession, it's okay. Possession, it's okay. With regard to the force majeure, if suppose the lockdown. In lockdown, it is not possible for to come out or run the
No, definitely, but your lordship, an NBFC doesn't provide the business services like a normal banking services where people come and operate the bank accounts and all. But in NBFC, they provide finances and loans. Obviously, those are defendants' personal documents which I shall not be accessible. I won't be having those access.
That you could
if being an NBFC, assuming if I don't have a document, they have the option to do their business or not to. If they chose not to do their business, then it's not my fault that I should be deprived of my.
No, that's why. Once they have taken the force majeure and you agreed with regard to the force majeure, and you are there, like, okay, it's a lockdown, but they had the business, they are NBFC. So you have to prove, okay, they have not appeared or they are not given or whatever it is. But you could have been taken these steps for producing their document that they had a business on that particular time. You're not
Even in their written statement, they have not run that case. And your lordship, their employees were coming. I have issued the gate passes.
Correct. On that day, okay. That's why when the 24th of March 2020 was the lockdown.
24th of March 2020 was lockdown.
When you first issued the gate pass and
gate pass was issued in 20th May 2020.
20th May 2020.
They appeared as per the government rule. They approached us and they provided the list of the staff members and we provided the entry pass to them.
Correct.
So the moment I provide the entry pass to them, how they are carrying out their business, whether
that's I'm telling. With regard to 24th of March 2020 or 25th of March 2020 till 20th of May.
For 2 months.
2 months. That
2 month I have no. Even they have not approached. In fact, in their written statement at para 10, even they are also not running that case, and they are saying that it was because of the government restrictions of the nationwide lockdown we have not done. But they are not saying that because of the restrictions and they waited till the country was entering into the unlock phase, they chose not to do their business or whatever. But they are not saying that I was not doing business entirely till October.
Which paragraph? The
para 10
statement
of the written statement.
Which para?
Para 10 of the written statement. On or about 25th March 2020, the National Disaster Management Authority of Government of India declared a nationwide lockdown for 21 days due to spread of the worldwide pandemic, being COVID-19. Due to such implementation, everything was shut down. Same was extended from time to time till amongst the beginning of June 2020. If this is their case, that till June 2020, they could not do business because of the lockdown, then why did they ask for entry passes to do in to the premises in May 2020? Even during post-June, lockdown was not totally lifted. The country was entering into unlock phase 1 with several restrictions still forced. Accordingly, there was a force majeure condition, and 11, they terminate the clause. And if your lordship takes the dealing of my paragraph 15.
And what was your, okay, what is your objection to this email? Have you sent a reply to this email of page 104?
Yes, yes.
What is the reply to the 104 termination letter?
Lordship, I'll just. Your lordship, the reply is at 106, your lordship.
This termination letter is dated, what is the date?
The letter dated is 30th May 2020. And we gave the reply on 5th June 2020.
105?
106. We refer to your mailing letter dated 30th May 2020 for termination of lease dated 2nd November 2018, allegedly owing to force majeure. In reply to your subjected letter, kindly note that you have acknowledged in your mail about having resumed your office operations with effect from May 22nd, 2020. You confirm that your staff visited the office and obtained entry pass. The entry arrangement put in place by us for health and safety of our lessees staff in the building. The above confirmation of resumption of office operation with effect from May 22, 2020 sufficiently negates your
your office staff visited
negates
the
your
office, but the
entitlement to claim termination owing to force majeure. Your claim that your office staff visited the office but work has not started due to pandemic is a cover-up to claim force majeure and is vehemently denied by us. The force majeure clause shall not apply after resumption of office. You, by virtue of your acts and conducts, have waived off your right to claim termination under the clause 14 of the lease deed. In view of the above legal position, your termination mail is in breach of settled terms of lease deed. You have video or email dated 26 May 2020 have been communicated details of the amount payable by you for early termination of the lease. The details are annexed here to as Annexure A for you doing the needful. Please note that this email is without prejudice to our rights and entitlement under the lease deed.
So they have terminated on 30th May.
Yes.
But
a better copy is at the judge's brief at page 83.
Yes. And they vacated?
They vacated on October 5, 2020.
October 5, 2020, after 5 months.
After 5 months.
After 5 months.
And the only benefit they are now trying is with regard to the lock-in period, the remaining 1 year, which in I have claimed in paragraph 15 of the plaint and dealt in para 42 of the written statement.
15.
My para 15 is
yes, your
claim.
Details are given.
Right, and 42 they have dealt. It is of the written statement. It is true that from March 2020, there was a worldwide pandemic due to the coronavirus. It is stated there was a force majeure condition, and accordingly, the clause contained in the agreement with regard to force majeure stood activated. As a matter of fact, plaintiffs by various emails already annexed herein above had admitted that there was a force majeure condition, which I don't know we have admitted. It is denied that there was any circular under which defendant was exempted from any lockdown. Lockdown and pandemic fell within the definition of force majeure as contained in the agreements between the parties. Defendant was not provided entry passes by the plaintiff primarily on the ground that the entry passes as required by the defendants were not issuable due to pandemic, which is a false statement because they themselves have admitted that their staffs have entered. However, in their emails, the plaintiff alleged otherwise, but were successful in not issuing entry passes. It is denied during 22nd May 2020 to 29 May, any official staff members of defendant were taking out any document or paper, which is again a false statement. Be that as it may, the defendant was well within its right to deal with and have possession of its documents and papers. It is for such reason complaints had also been filed by the defendant with appropriate police authorities. It is stated that the contents of email did not portray the correct interpretation of the law. I just pause here for a moment. On one hand, if I presume they were not doing businesses or anything because of the lockdown, but they can send people to the premises to take out documents. They can go to police, lodge complaints that my documents are not being allowed. I have to make compliance under the RBI. These are all part of their business. It is denied that there can be a It is denied there can be a lock-in period of 36 months or any part thereof. Otherwise, in respect of termination due to force majeure, then it's all denial. Then the contents of the email dated 30th May issued by the defendant are true and correct. The contents of 6th June issued by the plaintiffs were contrary to the agreement to the parties. It is denied defendant had commenced the office. So no case made out that I was not carrying out business due to the lockdown.
Yes.
It is not their case also. So
now only the period, because force majeure clause is there, 30 days time in the force majeure, but they have 25th of March till 20th May. 20th May they entered. So 20th May they started and they vacated.
They continued till 29th May. On 30th May they issued the termination notice, which I replied to on 6th of June.
Because immediately they are not vacated.
No. Even then, in their mail also they say that we are still continuing to be in position because we will be taking out
till October.
Even in October they went to court that the police is not helping us. Court said it's a civil dispute. You go file it out in a civil court. Then they approach at least let us take out allow us, because they were trying to remove the fit outs also. That's the plaintiff's case, which was customized and made only for the defendant.
Correct.
Then on October, plaintiff said very well, in presence of the parties, you take out whatever documents. That is the date, 5th of October, when the actual position was returned back.
So they are not filing any counter claim?
No.
They are not filing any counter.
No.
So what is your claim in this?
Lordship, my claim is in paragraph 28. The prayers are at page 24.
Decree of 20 lakhs
in favor of the plaintiff number 1 on account of
rent, paragraph 12. Paragraph 12 is
a decree for 42 lakhs in favor of plaintiff on account of breach of clause 3, which is the lock-in period. A decree for 17 lakhs in favor of plaintiff on account of mean profit for being in possession from May 31st to October 5.
Correct.
Then alternatively, an inquiry to be held into the quantum of the mean profit. Then the decree for 9 lakhs 4,617 in favor of the plaintiff number 2 on account of unpaid charges for the service agreement. For agreement dated January 10 up to December 31, 2019. A decree for 9,10,074 in favor of plaintiff number 2 on account of unpaid charges under the service.
Now with regard to the unpaid, what are the documents? Because till December it was 9 lakh was pending. There are what are the documents you have disclosed? These are the maintenance charges and service charges here not.
Yes, a lordship.
From which date?
Lordship. Dana. If your lordship takes 124 of the plaint, these are the invoices which were subsequently exhibited in the
124.
124, annexure L.
Correct. 2nd December 2019.
2nd December 2019. There's a 94,000 at 125. First is 11,800, which is with regard to parking charges. Then a service charge of 94,080,
Parking charge 10,000
Lordship.
for the month of
These are all for December 2019.
December 2019.
Multiple invoices were issued. Then at
service.
1,74,988 at 126.
So they have not denied this.
No, they in the affidavit of admission denial they have denied these invoices, but the documents were exhibited and they have crossed.
Without any objection.
No objection. The contents were approved.
So what are the contention during cross examination with regard to this document?
No, with regard to these invoices, no questions were made.
Questions.
No.
What about the claim of the plaintiff number 2? What is their contention with regard to the plaintiff numbers 2 service charges?
They haven't said anything. They said that the agreement was terminated with regard to since both the agreements are co-terminus, this agreement also automatically stood terminated with the main lease agreement. That was their main defense.
And with regard till the vacating the premises, what about the electrical charges and all these things? Who has paid?
Nothing, because since they have not adduced any evidence, even in the written statement is bare denial.
So now who has paid that? Because
nothing. It has been borne by the plaintiff only.
Have you adduced the witness evidence on that? What are the documents that you have paid the service other charges and the electrical charges and municipal charges?
Yes, if your lordship takes 130, the invoice was there. No, not invoice subsequent. During that period, I have not raised any invoices because the agreement was terminated. I couldn't have raised the invoices. But the services,
correct,
apart from the electricity, the other services, those were under the lock-in period. So, and those fit-out rentals. The main claim is on the fit-out rentals, not on the services which were not availed of during that period. But it is mainly is of the fit-out rentals which the defendant, plaintiff number 2 has invested on that property as per the customized requirement of the defendant.
If the court will say this with regard to the clause what on this 104, no? The force majeure. So they are right in terminating this. And with regard to the rent, okay, the 30th they have to give the 20th May, but they continue that they have to pay whatever it may be. So if it is declared that here the termination was correct, then what would be the plaintiff numbers to stand?
No, if even if the termination is correct, they continue to be assuming for the sake of argument.
Correct. That's what I'm telling.
Yes, that your lordship is with me with regard to that. Yes, the defendant was in wrongful position till October 2020.
That's why.
So, assuming your lordship, it has fallen from your lordship, you are entitled till October
2020.
So even then, they being in possession, and they continue to have the possession. So they continue to have the service charges also.
Correct. That's what I'm telling. So that is 20th May 2020.
30th May 2020 is the termination letter.
Termination.
And 30th
vacation October.
Yes. And if your lordship takes the 30th May letter, that email, it only specifies the lease. They don't terminate the service agreement. So if they don't terminate the service agreement continues. And in the service agreement, a major component is the service rental with regard to the fit outs. It's not only the services of the parking or the electricity or the staff or whatever, the security, but it's the main income is of the rental which the defendant at the very outset of entering into the premises made the plaintiff number 2 invest for their requirement, and were supposed to pay rentals on that, which they refused. So defendant's service rental income continues till the 36 months lock-in period. That they cannot deny because they have not terminated that agreement also.
Okay.
Even if your lordship says that no, the termination and the force majeure is for May 30th for the lease, which they have also terminated only the lease. They have never terminated the service. The service rental lock-in, they have to. They have not taken that ground that no service rental agreement. If the two agreements are separate and distinct, they have to terminate both the agreements.
So you meant to say that service agreement was never terminated?
Never terminated. It was only the lease.
Taken into consideration also the 36 months is a lock-in period.
Lock-in period.
So they are entitled to get the 36
They are
months.
entitled to. And even with regard to the lease, your lordship, I'll show to your lordship. Perhaps on the next day, I'll come back with a short note and along with the judgments, and it won't take much time. As I was saying, the Delhi High Court judgments that NBFC being an emergency services, they cannot avail the benefit of the lockdown. It is your wish, you chose not to do business. You had the emergency permissions. During the emergency period, you had that relaxation as an NBFC to carry out your business. You couldn't manage your staffs, or you couldn't enter, or you, despite you having the exit entry passes, you couldn't run your business. That's your problem. You cannot take the benefit. No, it was a force majeure situation, so I will terminate, because they saw that because of this, it's an good way to exit the business and close the Calcutta chapter and go back to Bombay. That was their main head office is in Bombay. So that was a good excuse to close the Calcutta chapter and went back to Bombay. So that's the main defense of the.
Okay.
So I'll just take another day and I'll just another 15 minutes. Just
these are the three.
These are the very short points. Okay.
None appears on behalf of the defendant. Counsel for the plaintiff has argued at length, but due to paucity of time, hearing could not be completed. According case is adjourned, let the matter appear on I am not fixing the time. I am giving the date. If time permit, I will take the matter.
It will just take 10 to 15 minutes, Your Lordship.
Okay, that's why I'm fixing
any short date, because since it's fresh in Your Lordship.
The matter appear on 29th August.
Lordship. Deeply. Deeply.
Yes. 12 तो हो गया ना 13.
I appear for the defendant respondent, plaintiff's application for amendment. Mr. Shobik Kundu was appearing on the other day.
My lord, I'm for item number 13.
Yes.
This is an application for amendment, my lord, and last order, my lord. Amendment of the plaintiff. I mean,
section 34 application.
Only the cost title.
Amendment in the cost title.
Yeah. Of
the section 34. Is a section 34? No. Is a why it is?
There was a
IP. Okay.
Last time my lord had asked us to service. This is the affidavit of service, my lord.
You are appearing for the defendant. Yes. What is your objection?
But only thing, though it's a formal nature, my lord, the amendment is of a formal nature. Documents on which they rely, my lord, those have not been annexed. Page 5, my lord, will find item B and C.
J1, J6.
Yes, ma'am.
J6.
J6.
Where is the proposed amendment? Proposed change name.
They have annexed the.
My lord, if you come to page 9, it's not page 9.
Page 34.
Page 34 is the amended.
Amended plain. That is.
So, Heinz Italia instead of Zydus.
Zydus. Zydus instead of Heinz Italia.
Zydus instead of
Heinz Italia.
Correct. And the paragraph 1, 2, 3, and 5, 7.
Only the Zydus has been. This is just the assignment deed, my lord. Para 2 says assignment deed. Heinz Italia SRL assigned the trademark in favor of its Indian subsidiary, Heinz Italia Private Limited. This is just the process through which it has gone. Para 3 says on 24/5/2019, the plaintiff acquired the shares of Heinz.
The paragraph 1, original paragraph 1 to 5 is to be deleted, and this is to be added.
Yes, my lord.
Okay. 1 to 7 is to be added.
1 to 7 is to be added.
The only thing is these two documents on which they rely for the amendment, my lord, they have not annexed these documents.
The annexes are there.
When your new name was amalgamated.
It is there, my lord. If you see annexer A, that is page 9.
But that's not the document, my lord. It's a filing receipt, my lord, with the appropriate authority.
This is the application you submitted.
Application, my lord, not the document, my lord.
Where is the order?
The assignment deed has been submitted at the trademark registry, my lord.
Correct. So where is
This is a post registration request hearing, so naturally it takes some time. It's still pending at the registry.
So it is not yet been changed.
Not yet been here. So
It is not yet changed.
not yet changed.
So if it is not yet changed, if today the plaint will be allowed and tomorrow your application will be rejected. So what would be the effect of this plaint?
The assignment is already there, my lord. So there is no chances of the assignment getting rejected.
Okay, it is your risk. If it is not there, you will be benefited.
Only thing, the documents are not there, my lord.
They're telling that it has not been finally assigned. It has not been finally assigned. It is still pending, but they are.
Even the deed of amalgamation, my lord, which they have referred to between the defendant, plaintiff and the applicant, my lord, that has also not been annexed, my lord. Rest I leave it to your lordship, whatever lordship.
Yes. So how you can prove this? Mere assignment, how? Unless until it has not been approved by the authority. How much time it will take?
My lord, give me 2 weeks time. I'll
Come after 2 weeks. As per the prayer made by the as per prayer made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on 4th September.
Grateful.
This is my application.
Yes.
But I'm supposed to give reply.
Yes.
my lord, only one thing, my lord. I've been, my lord, engaged in this matter. My lord, it's my learned senior friend's application under Order 12, Rule 6. My lord, I have, my lord, yesterday I have been engaged. My lord, I could not go to the entire volume. My lord, if my lord permits me to come back tomorrow, because he says he wants to give a reply.
In June.
I know, my lord. My lord, I have taken that instruction. Previous learned advocate was appearing. My lord, he has left the brief. My lord, I have been engaged yesterday night. My lord, kindly bears me with for 1 day.
Why your persons are accepting the brief which the case is fixed, especially fixed today?
No, my lord, I've told him, my lord.
You know the what the
I know, my lord. I absolutely bow down. But my lord, kindly, if can be taken up tomorrow.
Tomorrow the court will not go by your words, sir. The court has to go by your own diary. If I today I will adjourn the matter, then it will go to the November.
Any day.
Any day November. To pay the cost of 1 lakh rupees. I will adjourn the matter till November. No problem.
Kindly bears me, my lord.
This is the practice of this court. If you fix matter, adjournment, pay the cost, go. No problem.
Lord, I would
You persons know that the matter is 20th June. If the advocate has left, when the advocate has left?
Lord, I have been informed yesterday that he has.
Let the defendant face.
Lord, kindly bears me for the day.
No, sir.
Lord, I would be beseeching humbly.
I will give adjournment subject to payment of cost.
Lord, kindly, if Lord,
all advocates.
I can assure my lord on any day, my lord.
Any day. This court is not having any time. Any day. This court there is
much
still
assurance I can give, my lord.
Till full. This court there is full till the puja vacation. Before puja vacation, the other party will be prejudiced.
Well, it is the section 22 of the Hindu Succession Act.
I understand.
And they have shown
through that. Well, there is only one legal question I would make myself ready on section 22. Whether if it satisfies, I will come and say, my lord, it's satisfied. I will not open my mouth. And if it doesn't satisfy, then I will give a reply.
The judgments, it has been distinguished.
But today, my lord, it will be happening injustice to me and to my client also. My lord, today, if I open it half-heartedly, half-heartedly,
it is not done.
Lord, that's what I'm saying, my lord. I would be doing injustice being half-hearted. My lord,
the earlier advocate had argued the matter on they have also relied upon the citations.
Section 44.
44 of transfer of property act, my lord, debars me from entering into the Ejmali possession. That's the law. But on 22, I would come back because his admission is on 22. But 44 cannot give a judgment upon admission.
Correct.
But 22 is the only provision where he would, my learned senior friend would rely. Lord, only one legal question, Lord, I will look into and come back.
Problem is come back my diary.
that legal answer. Otherwise, things are there, my lord. I have purchased 50% share. He is owner of 50%.
Maybe that is just a factual
That's a
aspect.
factual,
list
my
of
lord.
dates
Judgment
is
upon
there.
admission has to be both on fact and law, my lord. Only that legal answer.
I can give the answer to my learned friend.
Why it has not been settling?
My lord, yesterday my lord, I could not.
They don't want.
Oh, settling. But
They don't. No. It is not going on. Letters have been exchanged. I am told we offered them the price at which they purchased along with the registration cost. They refused to accept. Yes, there are letters. No, please don't.
No, I'm জিজ্ঞেস করছি স্যার ওনার।
To take an instruction.
Given a written proposal, no written communication on there.
May I humbly submit this? My lord, they have concluded their submission to our trial advocate. I can place before your lordship the judgment in reply to distinguish that and a provision of law.
Lord,
And then whatever will come out.
I'll take 15 minutes. My lord, that's it. My lord, nothing more. 15 minutes. I will not
That
try
only
to do
the
anything
15 minutes of this court only.
15 minutes.
And it is come.
I will be as precise as I can be.
ऐसा कोई बीच में है कोई date?
Well, I know, my lord, but if it is possible, my lord, this side. Otherwise, my lord.
That's why I'm but
Well, I'm sorry to my learned senior friend, my lord. Extremely sorry. My lord is much senior to me.
No, I have not. I don't have any personal interest in any matter. The client is pressing upon me.
Adjoining, my lord, seniors, my lord, time, my lord, is also, my lord, something. My lord, we have learned.
Though the matter is especially fixed today at 12:30 p.m. for argument, but the land counsel for the defendant number 1 press for time. Accordingly, for the inter sub justice, the case adjourned. Let the matter appear on 15th of September at 12:30. It is made clear that on the date fixed, no adjournment shall be granted.
15 September.
Next.
New motion, item number 14.
Petitioners this side.
Eh?
I don't know what's. I mean, I was very confused. I was going to go sit that side and I was trying to recollect. I was not petitioner. I was respondent, if I remember correctly.
Changed.
Yes, my lord. It says that petitioner has come this side.
Why change?
I don't know. Huh?
Petitioner should be that side.
I'm very confused myself.
Okay.
It depends on whether the court starts with the left side first or the right side first. Anyhow.
So ठीक कर देना.
My lord, I'll try and conclude as fast as possible.
You got the time today now.
Yes.
Luckily.
My lord, it might come back to your lordship, my lord. I was on the question of the conveyance. Now, at this stage, my lord, without affidavits, my contention was that if I have come before the court with a prima facie case and a triable issue, the issue which needs to be heard, then, my lord, the question is whether the court in the meantime will protect my interests so far as the property is concerned. Here we are concerned with two defendants, one who has sold the property and one who has purchased the property. My endeavor was initially to show to your lordship prima facie that if you look at the mortgage deed, which has been, my lord, the rights of the mortgagee under that has been enforced for the purpose of the defendant number 1 claiming that I have a right to sell. That right to sell under the mortgage deed read separately would show that he had to give a prior notice before selling. To cover up that prior notice, my lord, he refers to a minutes of 10th. And he says that, well,
there was at some point of time, there was a no objection given. So that no objection, I am treating it as a notice, or I am treating it as a no objection or waiver of the notice, either way. Now, my lord, if your lordship reads section 69(2) from where I will start, it very expressly says that the right to sell without giving a notice has to be given in the mortgage deed itself, not otherwise. So it is not open to them to argue that by way of a subsequent contract, this consent was given. The reason is, my lord, 69(2), my lord, is a section 69, the power of a mortgagee to sell the property, my lord, actually is the last option given to the mortgagor to redeem the mortgage. That's the last option, number one. Number two, my lord, that notice under 69(2).
Yes.
That notice under 69(2), my lord, gives the cause of action of the mortgage to claim the money.
Yes.
So, my lord, starting from there, now, my lord, I'll just travel your lordship with 69 and then go to the authorities straight away. Authorities gulo bar kore rakho. এই My lord, your lordship has the transfer of property accounts. Oh, no, not done. Once a mortgage, always a mortgage.
Yes.
Well, this is where I ended. I'll just very briefly. A mortgagee or a person acting on his behalf shall, subject to the provisions of this section, have power to sell or concur in selling the mortgage property or any part thereof in default of payment of the mortgage money without the intervention of the court in the following cases and in no others. My lord, ours is C because it was a mortgage by deposit of title deeds, where the power of sale without the intervention of the court is expressly conferred on the mortgagee by the mortgage deed. Period. When the power of sale without the intervention of the court is expressly conferred on the mortgagee, kindly, my lord, mark the words by the mortgage deed.
Correct.
And the mortgage property and in part thereof was on the date of execution situate in Calcutta, then, my lord, this provision can be applied. So in all the three cases, A, B and C, my lord, your lordship will find the common element is that this power to sell without notice is in the mortgage deed itself. Our mortgage deed, my lord, I had pointed out on the last occasion, my lord, expressly says that you will have to give a notice. That, my lord, if you're not, I'm 160. Yes. Page 163, volume 2, my lord. Yeah, your lordship has made a note of it. My lord, 163, it starts 169. Clause 3, Roman 2 speaks of the notice subject to prior notice to the mortgagor. 163, it starts. Kindly come to 169. Clause 3, the mortgagor hereby covenants with the mortgagee as follows. Thereby, clause 2, notwithstanding anything contained in clause 1 above or elsewhere or in any other document, the whole of the loan shall, if so desired by the mortgagee, become forthwith due and payable by the mortgagee upon the happening of any of the following events, and the mortgagee shall be entitled to enforce the security subject to notice to the mortgagor. This notice is the notice under 69(2). And 69(2), my lord, says that the power to sell under 69(1) shall not be exercised. I'm sorry.
Yes.
The power, no power. My lord, it starts with the negative, no power, no such power shall be exercised unless and until a notice in writing requiring payment of the principal money has been served on the mortgagor or on one of the several mortgages, and the default has been made in payment of the principal money or part thereof for 3 months after the service, or some interest is there. So, Millard, the bar is here. If this is a bar, this agreement, Millard, squarely gets hit by it, because admittedly they don't say that I have given a prior notice, and my case is that property was sold without any notice to me.
Yes.
Now, in this scenario, when prima facie it appears, Millard, that it has been sold in violation, then, Millard, where do we stand at an ad interim stage? Can you, Millard, take the first authority on this, which is 88 Calcutta page 25. Thank you. Millard, DHO. Millard, I am relying on a judgment of All India Reporter 1988 Calcutta page 25. I had a copy. Yeah. Go on,
Yes.
Millard, here the issue was the impugned order of ex parte injunction was been assailed by Mr. Raju, the learned counsel, for the appearance on one or more of the grounds. None appears to be of substance to warrant our intervention. Then, Millard, the arguments have been recorded. Then, Millard, kindly come straight to paragraph 4. Mr. Swenso has secondly urged that an injunction restraining the defendant from transferring the suit property was absolutely unnecessary, as no post-suit transfer by the defendant can adversely affect the result of the suit because of the provisions of Section 52 of the Transfer of Property Act, whereunder all such transfers cannot but abide by the result of the suit. It is true that the doctrine of lispendence, as enunciated in 52 of the Transfer of Property Act, takes care of all pendentility transfers. Well, but it may not always be good enough to take fullest care of the plaintiff interest vis-a-vis such transfer. The suit giving rise to the impugned order is one for specific performance in respect of the suit property, and if the defendant is not restrained from selling the property to a third party, and accordingly a third party purchases the same bona fide for value without any notice of the pending litigation and spends a huge sum for improvement thereof or for construction thereon, the equity in his favor may intervene to persuade the court to decline, in the exercise of its discretion, the equitable relief of specific performance to the plaintiff at the trial and to award damages only in favor of the plaintiff. It must be noted that Rule 1 of Order 39, the Code, clearly provides for an interim injunction restraining alienation or sale of suit property. And if the doctrine of lispendence as enacted in 52 of the Act was regarded to have provided all the panacea, including pendentility transfers, the legislature would not have provided in Rule 1 for an interim injunction restraining transfer of the suit property. Rule 1 of Order 39, in our view, clearly demonstrates that notwithstanding the rule of lispendence in 52 of the Act, there can be occasion of grant of injunction restraining pendentility transfer in a fit and proper case. Then, Millard, the other judgments are recorded. So, this is, Millard, my first contention at this stage, that prima facie, your lordship will see whether I have made out some sort of issue to go for trial. If it is a triable issue, Millard, and it's a subject matter of the dispute is an immovable property, and I am challenging my challenging the deed by which, my lord, my title has been interfered with, then in that case, my lord, my submission would be that till such time it is heard, there should be some protection so far as further transfer, so that it doesn't create multiplicity of proceedings. That is one of the principles. My lord, apropos this, my lord, this is 2588 Calcutta. My lord, the other judgment which I'll cite, the principle remains the same, 2024, volume 11, SCC, page 351. Other side. নেই, আমারটা পড়ে দিচ্ছি, আমারটা পড়ে। Well, kindly will come to paragraphs 3 onwards. Permit me to place this in little detail because this is the appellants herein, who are the original plaintiffs before the trial court, instituted special suit number such and such for declaration, cancellation of registered sale deed dated such and such 23rd and permanent injunction against the respondents herein, that is the original defendant. In the said suit, the plaintiffs filed an application below, Exhibit 5, for grant of temporary injunction under the law. For the sake of convenience, the parties are referred to their nomenclature. Plaintiff number 1 to 3 respectively are real brothers, and 4 to 6 respectively are their respective wives. Defendant number 1 is the real brother of the plaintiff number 1 to 3 respectively, and defendant number 2 is the wife. Defendant number 3 and 4 respectively are sons of the 1 and 2, and so on. In brief, it is the case of the plaintiff that they purchased the suit property at the Cooperative Housing Society by way of a registered sale deed in the joint names of the plaintiffs 1 to 3 and the defendant number 1. By way of another registered sale deed executed on the same date, the first floor of the suit property was purchased by plaintiffs 4 to 6 and defendant number 2. Thus, the plaintiffs and the defendant number 1 and 2 became joint owners of the suit property, and their names were accordingly mutated. The plaintiffs and the defendant on 2 decided to start a jewelry showroom on the first floor, and for the purpose of development and construction, a power of attorney was executed. However, the remaining portion in November, the jewelry showroom constructed property stopped its operation. Anyway, Plaintiff 5 received a notice issued by the city survey officer under Bombay Land Revenue inviting objections, if any, against the recording of change of ownership in respect of the suit property. It is the case of the plaintiff that upon receiving the said notice, they inquired and found that the defendant number 1, on the strength of the aforesaid power of attorney, had executed a registered sale deed in favor of his son, defendant number 3, in respect of the suit property. So, my lord, facts are more or less, my lord. Being aggrieved, the aforesaid plaintiff instituted a suit along with an injunction application, being Exhibit 5, seeking reliefs as state for. The plaintiffs in their application Exhibit 5 for interim order pointed out the following. Then, my lord, the description, the arguments are there. Then, my lord, kindly come to paragraph. Paragraph 40. Paragraph 44, my lord. Or, my lord, paragraph 32 onwards, my lord, the principles of governing temporary injunction are being discussed.
Yes.
The burden is on the plaintiff to paragraph 32 onwards. In such and such, it has been held that it would not be appropriate for any to hold a mini trial at the stage of grant of temporary injunction. The burden is on the plaintiff by evidence alleged by affidavits or otherwise to prove that there is a prima facie case in his favor which needs adjudication at the trial. The existence of a prima facie right and infraction of the enjoyment of his property or the right is a condition precedent for grant of temporary injunction. Prima facie case is not to be confused with prima facie title, which has to be established on evidence at the trial. Only prima facie case is a substantial question being raised bona fide, which needs investigation and a decision on merits. Satisfaction that there is prima facie case by itself is not sufficient for grant of injunction. The court has further to satisfy the non-interference by the court would result in irreparable injury to the party seeking relief, and that there is no other remedy available to the party except one to the grant injunction, and he needs protection from the consequences of apprehended injury or dispossession. Irreparable injury, however, does not mean that there must be no physical possibility of repairing the injury, but means only that the injury must be a material one, namely one that cannot be adequately compensated by way of damages. The third condition also is the balance of convenience must be in favor of granting injunction. The court, while granting or refusing grant of injunction, should exercise sound judicial discretion to find the amount of substantial mischief or injury which is likely to be caused by the parties. If the injunction is refused, and compare it with what is likely to be caused to the other side if the injunction is granted. If on weighing competing possibilities or probabilities or likelihood of injury, and if the court considers that pending the suit, the subject matter should maintain in status quo, an injunction would be issued. Thus, the order has to be exercised in sound judicial discretion, granting and refusing an identity pending the suit. Then, my lord, kindly come straight to paragraph 44. 44.
Yes.
Paragraph 44. Quite often, in these types of litigations, litigations of delivery up and cancellation, the same prayers are over there. It is sought to be argued that an injunction restraining the defendant from transferring the suit property was absolutely unnecessary, as no post-suit transfer by defendant can adversely affect the result of the suit because of the provisions of Section 50 of the Transfer of Property Act, whereunder all such transfers cannot but abide by the result of the suit. It is generally argued. It is true that the doctrine of dispendence as enunciated in 52 of the Act takes care of all penalty transfers, but it may not always be good enough to take fullest care of the plaintiff's interest vis-a-vis such transfer. We may give an appropriate example. Then, my lord, this 88 Calcutta example has been repeated here, and thereafter, my lord, an injunction was granted.
Yes.
So, my lord, the point, my lord, which I am trying to raise is, if there is a conveyance, then my title is not disputed. If it is sold by way of a mortgage, then obviously, my lord, that also, my lord, my title is not disputed. Admittedly, there is no notice prior to the sale. The notice provision is supposed to be covered by way of that 10th minutes. And the 10th minutes, I have stated expressly in the plaint, was not for the purpose of giving him a right to sell. If your lordship reads the entire 10th of minutes entirety, my lord, it was basically me trying to purchase him off, failing which he will have a right to sell. But that, in my respectful submission, I had two submissions to make. That notice was not followed up, because subsequent to that, because if he had an exclusive right to sell and I have given him the right to sell, that notice was subsequently followed up by the two lease deeds, where they expressly admit me as the owner, and they say that I have paid the money which has come from leasing out the property to West Side, my lord. That entire money has gone for repayment of, my lord.
The lease deed is after these minutes?
Yes.
What is the date of the minutes?
My lord, date-wise, my lord.
Date of minutes was?
The date of the minutes would be 10th of May 2024.
10th May?
2024.
Yes.
And, my lord,
lease deed?
This lease deed was granted on 6th of March 2025. It's way after a year. And, my lord, this property was first attempted to be sold, my lord, in March, which will appear from that order of the register, and ultimately sold in June without notice to me. So, my lord,
what was the occasion for minutes of the entering into the minutes of the meeting, the resolution?
my lord, according to me, my lord, as I have stated in the plaint, the minutes was, my lord, at that point of time, your lordship will find that the project was not yet complete. We were actually my lord, running after this Berlin to complete the project sometimes, my lord, in 2 years, but it spilled over because of COVID for whatever reasons. Now, at that juncture, my lord, when it came to our knowledge that he's already, my lord, mortgaged a portion of the property against a loan, number one. Number two, my lord, if I can buy him off at whatever rate he quotes, then I get the right to deal with the property for my benefit.
Correct.
Now, that minute continues to go and say that in the event, your lordship will find that there are 2 time frames given. All those time frames, my lord, had expired in 2024 itself. And Merlin, for once, my lord, has not even written to me that, look, you wanted to pay me off. So the time for payment of the first installment is over. You are not paid me. And subsequent, my lord, of 10th of May till date, my lord, your lordship will find there is no reference of this in the minutes. The parties have gone away as if, my lord, they performed the contract. When ultimately, my lord, these minutes again surfaced when it was required for him to show that I had given consent to sell. So, in my respectful submission, my lord, if this minute was intended to give him a right to sale, then that has to be in modification of the first agreement where my 52% right is protected. Now, that original deed of 2019 expressly says that it cannot be modified except in writing, indicating a clause that the 10th minute doesn't seek to modify, number one. Number two, my lord, in any event, it cannot be modified because the 2019 agreement was a registered agreement.
Yes.
It could only be altered or modified by way of a registered document. That is not there, legally speaking.
Yes.
And, my lord, thirdly, that 10th minutes also cannot, my lord, take away that right of mine, which is, my lord, protected under section 69(2). So these are the 3 things, my lord, which will stare at whoever is trying to argue that the 10th minutes gives them the right. That, and, my lord, if he is to execute the mortgage amount is only to the extent of 29 crores. So even if he gives me a notice, he can only recover 29 crores for me. He cannot ask for 130 crores, which is his 42.5% share as he has valued.
Leaving aside.
So his claim under the mortgage would be only 30 crores. So that's the reason if he is enforcing the mortgage, his claim cannot go beyond that.
Yes.
Now, my lord, the only other thing I'll conclude, 15. Lordship is in the moment. The lordship gives you one moment, my lord. Yes. My lord, this is All India Reporter, 1958 Supreme Court, page 770.
Yes.
Well, kindly consider paragraphs 6 and 7. This is, my lord, my recognition of the right vis-a-vis the property.
Yes.
The rule against clogs, my lord, paragraph 6 and 7. The rule against clogs on the equity of redemption is that a mortgage shall always be redeemable, and the mortgagee's right to redeem shall neither be taken away nor be limited by any contract between the parties. If at the highest the 10th is taken to be a contract limiting that right, it cannot be. The principle behind the rule was expressly in Lindley versus such and such in these words. The principle is that a mortgage is a conveyance of land or an assignment of chattels as a security for payment of a debt or the discharge of some other obligation for which it is given. This is the idea of a mortgage, and the security is redeemable on payment or discharge of such debt or obligation. Any provision to the contrary, notwithstanding, that is, in my opinion, is the law. Any provision inserted to prevent redemption on payment or performance of the debt or obligation for which the security was given is what is meant by a clause or a fetter on the equity of redemption, and is therefore void. It follows from this that once a mortgage, always a mortgage. The right of redemption, therefore, cannot be taken away. The courts will ignore any contract, the effect of which is to deprive the mortgagor of his right to redeem the mortgage. One thing, therefore, is clear, namely that the term in the mortgage contract that on the failure of a mortgagor to redeem the mortgage within the specified period of 6 months, the mortgagor will have no claim over the mortgage property, and the mortgage deed will be deemed to be the deed of sale in favor of the mortgagee, cannot be sustained. It plainly takes away altogether the mortgagee's right to redeem the mortgage after the specified period. This is not permissible, for once a mortgage, always a mortgage, and therefore always redeemable. The same results also applies for Section 60 of the Transfer of Property Act. Similar, this 69(2) notice which bars sale is in recognition of this right of mine.
Yes.
So any contract, even if it is alleged that I have given up my right, the court says that it cannot be taken into consideration. Now, Miller, this is so far as, Miller, the plaintiff number 1 is concerned. I'm sorry, the defendant number 1 is concerned. So far as the defendant number 2 is concerned, Miller, kindly now take the plaint ones.
Hey, print there. You're not enclose the print here.
Or, Miller, your lordship comes to the injunction application. It's a reproduction of the plaint, I presume. Paragraph 35. The petitioner, this is when I come to know of that sale. The petitioner made further searches and inquiries and consequently came to know that the respondent number 2 is a company which was incorporated as date on 30th of December 2023. At the time of incorporation, the registered address of the respondent number 2 was Astra Tower, Rajarhat. It has an authorized capital of 1 lakh and paid off capital of 10,000 only. The company was incorporated by one Miss Shurobi Jain, resident of Vikram Bihar, GT Road, Shivpur, Howrah. The said Shurobi Jain became a director of the company as recently as on 20th May 2025. May 2025.
Yes.
The authorized capital of the respondent number 2 was increased to 50 lakhs only on 20th of May 2025. The transaction took place in June. It has come to the knowledge of the petitioner that on 20th May 2025, the respondent number 2 opened the bank account with Axis Bank with an opening balance of 25,000 only. On 2nd June 2025, the registered office of the respondent number 2 changed to its present address at 9 Krishna De Road, such and such, Alipur, New Alipur Station, such and such, West Bengal. On 3rd June 2025, 4,90,000 shares of the respondent number 2 were issued for an amount of 49 lakhs. The documents in support of the above contentions are at R. These are what I could gather from the website. So, Miller, point which I am trying to address or Miller impress upon the court is that a company which in May 2025 had an authorized share of 49 lakhs, Miller, had opened up a bank account, Axis Bank, of 25 lakhs, through which an entire transaction of 235 crores has been done. My lord, on affidavits I'll come, but my lord, apparently, my lord, I shouldn't say it shocks the conscience of the court, but my lord, it's worth having a look at it on affidavits. This is all I'm trying to say. And so far as my lord, so far as the another fact, my lord, which struck me. Kindly, my lord, take page 341.
Yes.
My lord, your lordship will remember on the first day I had shown to your lordship, my lord, that so far as this conveyance is concerned, there were two attempts to sell. First was in March, when, my lord, this price was fixed at 16 crores and or with the stamp 16 crore 45 lakhs, 16 lakh 45, 16 crores, no, 45 lakhs.
16 crore 45 lakhs.
Yes. Now, my lord, it is a purchaser. I mean, so far as I know, subject to correction by all of them, my lord, is that the person who sells pays capital gains tax and the person who purchases pays the stamp and the registration. This was the registration which has been paid at 341. Kindly, my lord, see 6. Who has paid these 16 crores 45 lakhs? By whom tendered? Well, 5 is the amount, 16 crore 45 lakhs.
Merlin. Yes.
Now, having paid 16 crores as a seller of stamp duty, my lord, what he does, my lord, at page 309. $309, my lord, is an annexure which has been sent to me, being part of the mail. When I tell him that he says, I am sending you a sheet. This is what is payable to you after adjusting my dues. So what he does, at the top, your lordship will find total considered and amount received 2 crore 235.
Yes.
The first thing he adjusts from this
16 crore. So from your pocket.
So he sells, the purchaser is not paying the tax, the seller is paying it, and the seller adjusts it with the owner's account.
Yes.
So, beloved, what more can I say if it is argued that the respondent number 2, Millard, is a bona fide purchaser for value? He is not. He goes to purchase a property without having the money, not Millard, the capability or capacity to pay even the court fees. The seller pays the court fees for him. And not at 1 rupee, 10 rupee, 15 rupee, 16 crores, 45 lakhs.
Yes.
And thereafter, Millard, passing it on, which shows, Millard, how the attempt of Merlin is to deprive me of my property as well as Millard. So, Millard, in these circumstances, I am praying for an order of injunction restraining from further dealing with the property till affidavits are exchanged. And my lord, more evidence comes for the purpose of deciding whether I have a triable issue. This is only my side of the story, depending on what documents are. And none of the documents which are in writing can be, my lord, improved upon by any sort of oral submissions. Those would be my submissions.
Me, my lord, we have for different number 2.
Two or one?
One, my lord, is Mr. Mitra.
Hmm.
Oh, no, we can. The other one too.
कल क्या है? कल क्या है?
Oh, Millard, I'm sorry, I missed one thing. Though Millard, it doesn't have an affidavit, but I'll give copies to my learned friend. Millard, even today's website.
Oh no.
এটা কি? এটা জানতে পেরেছি আজকে জানতে পারলে।
Yes.
Millard, these are the websites.
Yes.
Where Millard, the commercial properties are listed for sale. And Millard, the sale is taking place, Millard, at the instance of Merlin. Merlin, the Statesman House overview. This is what I have come to know. So Millard, it is on first. They are planning to sell it, whether through Merlin, through Hatishala, according to makes no difference. But this is what we have been able. If your lordship wants, Millard, I can file an affidavit affirming what I have got it and from where I have got it. Otherwise, Millard, 65B may come into play. I have given them a copy.
हाँ क्या बोले?
Affidavit করে দাও।
22nd सुबह आज 19-20 कुछ नहीं है, खाली नहीं है। 20-21
আমি এফিডেভিট করে দিই। এফিডেভিট করে ফাইল করব, কপি তো পাবি।
और
हाँ
20 को क्या है? वो है 22nd नहीं है। 22nd मॉर्निंग
Morning, 11:30. 10:30 तो बोला
10:30 after mentioning matter I will take
10. Yes, 10:30 I think. हाँ.
Learned counsel for the plaintiff has concluded the argument for grant of interim order. Due to paucity of time, defendants could not argue the matter. Let the matter appear on 22nd August at the top. Record an order. Though the matter is fixed, especially fixed today at 2 p.m., but the learned counsel for the defendant prays for time. This court has fixed the matter, especially fixed the matter today at 2 p.m. by an order dated 16 June 2025. But in spite of having the knowledge that the case has fixed specifically, in spite of the same, the learned counsel for the defendant has prayed for time. Accordingly, case is adjourned subject to payment of cost of rupees 75,000 to the High Court Legal Service Authority. High Court Legal Service Authority. Let the matter appear. Give the number one date. Let the matter appear on 6th November 2025 at 2 p.m. It is made clear that by that time the defendant failed to pay the said amount, the vendor defendant defense will be closed. Yes, call the list.
In that case, we were to file our affidavit in evidence. We have prepared this, served it upon him. If we may file it, we'll tender it on the next time.
We have also paid the cost.
Cost has been paid.
That's why I put the cost to them. I know the order.
They have taken the time from the month of.
That's why last date I fixed the. That's why I fixed the on that day. I
am praying for time.
Without examining the witness, you started the adjournment. You could have been wait what they are doing. Automatically the cross would have been deferred. But you have starting when the case is not taken, the court has not called. You have asked for the adjournment. Let you go to pay the cost. Yes. Call the list.
Let that affidavit in evidence filed.
Only then affidavit of evidence filed by the plaintiff be kept with the record. Yes. Who is there? None appears on behalf of either of the parties. No accommodation is sought for. Let the matter appear in the combined monthly list of November 2025. Next.
Item 16, my lord. My lord, my GA is there, my lord. May I just, my lord, at the outset, my lord, pray for one difficulty. But I was addressing, my lord, courtroom 39, my lord, and the matter is to be taken up right now, my lord. May I just come back, my lord, at 3 o'clock?
Number. If you are joining a number.
But may I come back?
Though the matter is called today, but the learned counsel for the plaintiff.
And for the defendant, my application for written statement.
Time accordingly, case adjourned. Let the matter appear in the combined monthly list of November 2025. Yes, next. None appears on behalf of either of the parties. No accommodation is sought for. Let the matter appear in the combined monthly list of November 2025. Same order. Same order. Same order. None appears on behalf of either of the parties. Let the matter go out of the list. None appears on behalf of the parties. Let the matter go out of the list. Same. Let the matter appear in the combined 25. Let the matter appear in combined monthly list of November. 26. None appears. List the matter in the combined monthly list of November. None appears on behalf of the other party. Let the matter appear in combined monthly list of December 2025. 28. December 2025. 29. December 2025. December 2025. December 2025.
Minus kindly.
Call. December 2025. Nobody's appearing.
Lordship, Lawrence Council appearing for the respondent, he'll make another more short pass over, Lordship.
When the matter is called, none appear, Learned Counsel for the defendant has prayed for time. Let the matter adjourn. List the matter in the combined monthly list of November 2025.
Kindly keep it before, Lordship, kindly keep it any.
December 2025. December 2025. December 2025. December 2025. December 2025. December 2025.
My lord, item number 38, my lord, I am appearing on behalf of the decree holder, my lord.
Yes. You the 38.
My lord, I appear for item number 19, my lord. Nobody
19 is
added
over.
me.
19 is, with the matter is over, that is over. I will not call. What order passed. Neither mentioning. ये एक note कर लेना सारा matters का. No mentioning.
No, my lord, today my interim order was expiring.
Maybe. When the matter is called, nobody is
request.
there, let the matter go.
No, my lord, I had sent my request
When the matter
long
is
back,
called,
my lord, I
none
was not
appears,
admitted.
matter will be listed in the combined monthly list November, sir. The court is not sitting idle here.
No, my lord, no, you kindly extend the interim order. Kindly extend the interim order then, my lord.
Nobody is appeared. How the interim order will be extended?
My lord, I had sent my request, my lord. No, I am not, my lord. My lord knows me, my lord.
Yes. 38 years, who is appearing for?
My lord, item number 38, I am appearing for the decree holder, my lord.
Yeah.
In this matter, my lord, the respondents have already promised us to make payment of the decretal amount, my lord. I am humbly seeking that the matter be kept in the next month.
Why?
My lord.
Let it come in the month of November. If they will pay, you mention, I will dispose of. Otherwise, come in the month of why I should keep in the next week.
My lord, the judgment debtor has sought for 1 week's time to make payment of the amount, my lord. In that case, if it could be kept in the month of September.
Counsel for the decree holder submit that the judgment debtor has informed the plaintiff that he will pay the decretal amount within a week. Accordingly, the decree holder pays for a week time. In view of the submission made by the counsel for the decree holder, case is adjourned. Let the matter appear on 2nd of September 2025. Yes, next.
Grateful.
Well, item 19, my lord, extend the interim order. My lord, the suit will infructuous.
Sorry, maybe infractious, maybe when the matter is called, the court is sitting idle, somebody is appearing. Yes, call.
My lord, annoyed, my lord.
39.
My lord, appearing on behalf of the petitioners, my lord.
Yes.
On the last occasion, there was a direction upon the judgment debtor to file affidavit of assets, your lordship.
Who is for the judgment debtor?
Your lordship, on the last occasion, Mr. Varun Kothari and Ranjana Sheel, they were appearing.
None appears on behalf of the judgment debtor. The matter was fixed on 28th of July 2025, and on the date fixed, the Learned Counsel for the judgment debtor prays for time to file affidavit of assets. But when the matter is called today, neither the affidavit of assets is filed, nor any accommodation is sought for. Full stop. In view of the above, let the warrant be issued up against the judgment debtor. Full stop. The decree holder is directed to take appropriate steps to file requisites in the department for issuance of the warrant against the judgment debtor. List the matter on 9th of September 2025. Next. November 2025. None appears on behalf of either of the parties. No accommodation is sought for. List in the combined monthly of November 2025. Next.
41.
Same. None appears. No accommodation. November 2025.
But I'm for the defendant.
Yes. Give the list.
I'm taking out an application, my lord, for
My lord, I appear for the decree holder, my lord.
for some of the defendants seeking, my lord, seeking the transfer of proceeding, an execution proceeding, my lord. I am outside India. As against me, that's my contention. Lordship asked me to take out a formal application. I have taken out. It's being affirmed. It's a master summons, so it will take 4 days time. Lordship keeps this after, my lord, or in next week, my lord, will come back.
As per prayer made by the counsel for the judgment debtor. Yes, he said.
Number 1, 2, 3. I'm for 1, 2, 3.
Judgment debtor.
Now, my lord, for the rest of the judgment debtors, my lord, they were supposed to file their affidavit of assets. That has not been forthcoming, my lord, as of now.
Counsel for the judgment debtor number 1, 2, 3 prays for time to take appropriate steps. Full stop. Counsel for the decree holder submit that the other judgment debtor have neither, they are not appeared.
My lord, they have appeared, but many have appeared, my lord, but they have not filed their affidavit of assets.
6 and 7. Other judgment debtor have neither appeared, have not filed affidavit of assets. In view of the above, the judgment debtor number 1, 2, and 3 has given liberty to take appropriate steps within a week from date, as the other judgment debtor have neither appeared nor have filed their affidavit of assets, that the warrant be issued against the other judgment debtors. The decree is directed to take appropriate to file requisites in the department for issuance of warrant against the judgment debtors number 4 to 7, 4 to 8.
Yes, my lord. Apart from the defendant number 1, my lord, all of them.
4 to
The
8.
judgment debtor number 1, my lord.
4 to 8, 4 to 8. Yes, next. List the matter on 9th September.
Grateful, my lord. Deeply obliged.
Item number 18, my lord.
Which has gone.
Written statement. I have filed an application file.
Maybe gone. Come in the number. The court is also having a heavy load. Now it will be reduced.
Because of that 1, 2 p.m. matter, we did not know it.
What can be done? 2 p.m. matter, you all persons will be, your juniors are not there. Once you are appearing, when I am passing the order, I find the 6 or 10 names. When the case is called, nobody is there. You might be busy. Where is your junior?
Similarly, item number 19, the interim
I
order
am not taking any matters which have already passed an order for shifting the matter.
clients will be prejudiced, Millard. We were here, Millard.
So if you are taking the prejudice of the client, why you are not sitting in the court?
I had sent the link. My clerk was there. My clerk was insisting your lordship's officer to admit me. Millard, it was not admitted on time. It has gone so fast. Millard, it is not Millard. Nobody's fault, Millard. We are there, Millard. I am always there, my lords, Millard. Call Millard. Millard, kindly, Millard. The client will suffer, Millard.
Sorry.
Millard, kindly extend the interim order and keep it in the month of.
Once already I have extended, how the interim order can be extended?
It is expiring today, Millard.
Maybe expiry, interim order is expiring today. Why you are so negligent?
Millard, I was there online. Millard, I could not be admitted. Kindly, Millard, ensure.
Sorry, madam, sorry.
Millard, kindly ask Millard, my lord's operator, Millard, he could not admit me on time. He was also, Millard, got puzzled with the Millard so fast, Millard, the matter has been called. I was there, Millard, before from 2 p.m. I was there. I never take my
this is already recorded. If the matter is urgent, the serially it will be taken. Nobody.
Yes, Lordship.
The court was totally blank.
Millard, I'm so sorry, Millard. I was there.
Oh, sorry. Let your bar take lesson from today's orders. Then answer will see to that. Sorry, madam. Not to say anything further. Yes. Who is appearing?
Lordship, item number 44. Lordship, I appear for the plaintiff in this matter.
Which matter, madam?
Lordship, item number 44.
43 it is called. Who is appearing? None appears on behalf of either of the parties. No accommodation is sought for. List the matter in the combined monthly list of December 2025. Yes, call the 44.
Lordship, 44, I appear for the plaintiff in this matter. It is listed for arguments today. Lordship will kindly take it up, or Lordship will adjourn it for tomorrow.
I am ready. Argue otherwise.
Right. Lordship. No, Lordship, I'm starting. Lordship, the plaintiff, if Lordship will kindly see. Lordship, the instant suit is based on dishonor of check. The check was, it was a loan granted by the plaintiff to the defendant for a sum of rupees 25 lakhs. Lordship will kindly see page 60 of the plaint. Page 60. Yes, Lordship. The amount of the check for the principal amount, that is 25 lakhs.
Yes.
This was, Lordship, this amount was transferred by way of RTGS to the defendant. That is at page 46. Lordship will kindly see at page 46 of the plaint. A sum of rupees 25 lakhs has already been transferred. Number 2, Lordship will see on 23rd of June 2016, Supreme Freightway Carriers, a sum of rupees 25 lakhs has been transferred.
By whom? Plaintiff to the defendant?
By the plaintiff to the defendant, Lordship.
46.
Lordship, 46.
RTGS.
Yes, Lordship. That is a copy of the bank statement. Once the loan was remitted to them, Lordship, they have given an acknowledgement letter that they have received the loan. That is at page 47. Lordship will kindly see at page 47 of the plaint. There's an acknowledgement. Page 47, Lordship.
Yes.
Yes, it says Supreme Freightway Carriers have received an account loan amount of rupees 25 lakhs for the period of 120 days. Agreed rate of interest 12% per annum from Overshore Enterprises. Overshore Enterprises is the plaintiff, Lordship here. White RTGS in our HDFC bank account. So they are acknowledging the entire thing. And once this loan was granted and the acknowledgement they had given to the plaintiff, Lordship, the loan was renewed from time to time because they were paying the interest. But that interest can be seen from page 48 to 50, Lordship, of the plaint, where we have annexed the TDS certificates. Lordship will kindly see number 2, page 48, Lordship.
Yes.
Number 2, it says Satish Agarwal Deepak. So that the name of the defendant is Deepak Agarwal.
Yes.
He's also known as Deepak Satish Agarwal also. So he is paying the interest.
Okay.
Similarly, at page 49, Lordship can see item number 1.
Yes.
They are depositing TDS.
Yes.
And again at page 50, Lordship, item number 1.
Yes.
So these are the interests that they had deposited. Thereafter, Lordship, we had the plaintiff had recalled the loan because they were not paying the amount.
Okay.
And such, when the loan was recalled, they have issued a Lordship.
Where is your recalling of loan?
Lordship, that was done verbally initially because it was on demand. So it was done verbally and they have issued the check of the amount at page 59. Lordship will kindly see that they had issued a check on 1st of April 2029. 2019. My apologies. 1st April 2019, they had issued a check for the principal amount, but eventually they wanted to continue with the loan, and so they said they had asked us not to deposit the loan, and in return of the same check, they have issued the new check, which is at page 60. Lordship will kindly see at page 60.
Page 60. What about the 59?
59 was the initial, when we had asked for, when the plaintiff had asked for verbally for recalling of the loan, they had issued the check. But thereafter they had requested the plaintiff not to deposit it because they were wanting to continue with the loan. And accordingly, they had paid interest also. That I have already shown to my lord.
Then
Thereafter, Lordship, it was again renewed, and they did not pay again. They stopped paying the interest component. So the plaintiff had asked to refund the entire loan amount, but and then the defendant had issued this 1st December 2019 check, which is at page 60.
yes, got it.
After this, Lordship, we had deposited this check. This check got dishonored. And after dishonor, Lordship, we have already filed, the plaintiff has already taken steps under the Negotiable Instruments Act and filed and also sent a demand notice, which demand notice is at page 76 of my plaint, Lordship.
Where is the dishonor notice, check return memo?
Lordship, at page 61.
61, check return clearing. What is the reason? Where is the reason?
Reason, 1 second, Lordship. The reasons for return, Lordship, is from page 63. I can see. I'll just come to that, Lordship.
Okay, then thereafter.
Then, Lordship, we had already issued a section 138 notice, which is at page 76 of my page 66 of my plaint, Lordship. Page 66. That the date of the notice is 27th January 2020. Yes. This was under section 138, read with 141 of the Negotiable Instruments Act. It was sent to them. The track report is at page 70, Lordship, which they have received. Item delivered to addressee. Thereafter, we have also issued the demand notice at page, which is at page 76. 76 of the plaint, Lordship. It has been sent by mail also.
Yes.
So we have asked for a sum of rupees 29,73,973 rupees, Lordship, and the demand notice has been annexed in that email. Lordship will find the annexed document on page 76, and page 77 onwards is the demand notice.
Yes.
So this demand notice also was sent, and this was sent. Yes. Just 1 second.
But the second notice was served upon or not?
Lordship, this was served. This they have received at page 76, which is at page 76. They have received this, but the one at page 81, which we have sent later, that they have not received.
Okay.
This, no, if I am, no, Lordship, I'll just stand corrected. This they have also received. No, yes, Lordship, at page 781, which is the notice that they have, that has come returned. That has been returned to the office of the learned advocate.
Okay. Yes.
Yes, Lordship. And
have you
so, yes, Lordship, we had adduced evidence. Since it was done ex parte, they were not appearing, Lordship.
Yes.
Just give me 1 moment. So even in the evidence, Lordship, it is clear that the plaintiff has already given the amount and they have received the amount, and they have failed to give failed to pay back the dues of the plaintiff, Lordship.
By which order the case was proceeded undefended?
Lordship, 1 second. Lordship, just. Lordship, by 24th January 2025. 24th January, Lordship. Lordship comes to the last third paragraph. It says, in view of the above, let CS Com so and so be placed in the list of undefended suit. 24th of January 2025.
Yes.
Lordship, I'm humbly praying that a decree be passed in favor of the plaintiff for the amount as mentioned in the plaint, Lordship, and interest till payment. Prayer A, prayer B, Lordship. At page 12 of my plaint.
The plaintiff has filed the present suit, praying for a decree for a sum of rupees 31 lakh, along with interest at the rate of 18% per annum. The plaintiff is a private limited company and carrying the business of finance as well as investment in share and securities. The defendant has approached the plaintiff seeking a loan amount of rupees 25 lakhs and represented the plaintiff that the said loan was required for short-term period for the smooth operation of the business of the defendant. As per the request of the defendant, the plaintiff has transferred an amount of rupees 25 lakhs by way of RTGS from UCO Bank. And the same was duly received UCO Bank in the name of the defendant, and the same was duly received at the defendant, and the defendant has acknowledged the said amount of rupees 25 lakhs by a communication dated has acknowledged the same 25 lakhs by a communication. What is that? And this exhibit, this acknowledgement?
Yes, Lordship. One second, Lordship.
In the said acknowledgement, the defendant has stated that he has received the amount of rupees 25,000 lakh for a period of 120 days and agreed to pay interest at the rate of 12% per annum. 12% per annum.
Lordship, Exhibit F.
After the receipt of the said amount, the defendant time to time has paid interest to the plaintiff, which appears in the TDS certificates, which were marked. TDS certificate marked?
Yes, Lordship. G. Exhibit G.
TDS is not exhibited. Exhibit G is your bank statement.
Lordship, it was together along with the bank statement. If Lordship kindly happens to see the judge's brief of documents.
I think.
At page 2, item number 7.
In judge's brief of document, which page? Your TDS?
Lordship, page 34, from 34 onwards.
That is not marked. TD certificate submitted by the plaintiff, which are marked as exhibit G collectively. G collectively. Full stop. When the last interest was paid, the plaintiff has, the defendant has paid the last interest to the plaintiff. When the last interest was paid,
I will just read out. 1 second, Lordship. This was Lordship till January 2019.
January, till the month of January 2019, and thereafter the defendant failed to pay the interest or to return the said amount. Subsequently, the defendant had issued a check of rupees 25 lakhs, but the defendant has requested the plaintiff not to present the said check, and subsequently, after taking back the said check, another check was issued for an amount of rupees 25 lakhs dated 1st of December 2019. The plaintiff has presented the said check for encashment, but the same was returned without same was written with the endorsement funds insufficient. Full stop. Subsequently, after return of the check, the plaintiff has issued notice to the plaintiff and defendant, but in spite of receipt of the notice, the defendant has not paid the amount. Accordingly, the plaintiff has filed the present suit for recovery of the amount. To prove the said case, the plaintiff has examined one witness, namely
Arun Kumar Lakkar.
Arun Kumar Lakkar, LACK Lakkar, and during his evidence, altogether 11 documents were marked as exhibit, being exhibit A to exhibit O. Exhibit A to exhibit O. Full stop. From the exhibit F and exhibit where is your bank statement? 25 lakhs transferred RTGS, that is not exhibited here.
Yes, Lordship. It is exhibit E. Bank statement of the plaintiff at page 32 of the judge's brief of documents.
From the exhibit E, that is the statement of bank statement of the plaintiff, proves that on 22nd of June 2016, an amount of rupees 25 lakhs is transferred by way of RTGS in the account of the defendant.
Lordship, it will be 23rd June.
By an exhibit F, the defendant has admitted that he has received rupees 25 lakhs and also assured that he will pay the interest at the rate of 12% per annum. Full stop. In spite of receipt, full stop. The TDS document and the other bank statement shows that after receipt of the said amount, the defendant has paid interest for some time, and subsequently the defendant failed to pay the interest or to return the principal amount. Subsequently, the defendant has issued a check of rupees 25 lakhs dated 1st of December 2019, being annexure H, but the same was also dishonored with the endorsement funds insufficient. The plaintiff had issued notice upon the defendant, but in spite of the receipt of the notice, the defendant has neither paid the interest nor has paid the principal, nor had returned the principal amount. Full stop. Considering the above, this court find that the plaintiff has proved the case and is entitled to get an amount of rupees 25 lakhs along with interest at the rate of rupees 12% per annum. 12% per annum. The defendant was directed to pay an amount of rupees 25 lakhs to the plaintiff along with interest at the rate of 12% per annum from 1st January 2019 till the realization of the total. CS number so and so, CS number CS com है ना? 1st January 2019, 1st January तक का दिया था ना? जनवरी ना? लास्ट इंसेट 31st of 2019 नहीं, वो 31st होगा क्योंकि इन लोग भी वही कर रहे हैं. नहीं 2018. Madam, last interest when it was paid?
Yes, Lordship, it will be 31st December 2018 because it is calculated from January 19.
ठीक है. CS com number CS com 248 of 2024 within bracket old CS 49 of 2021 is disposed of, decree bit on according.
Yes, Lordship.
Yes, call the list.
Deeply obliged, Lordship.
Yes.
I'm for the plaintiff myself.
Yes.
Now, my lord, this is an undefended suit. It pertains to an insurance claim.
Yes.
Now, my lord, since the document is very voluminous, I have prepared one convenience brief for your lordship containing the plaint, affidavit of evidence in chief, and the deposition of one witness examined and cross-examined. Now, my lord, before going into the documents, I would like to give a brief overview of the entire dispute. The plaintiff is a trader of computer and computer apparels and allied merchandise. And at that point of time, it is one of their principal businesses. They had other businesses also. And that point of time, most of the merchandise they were selling in India through their different outlets and different distributors were imported materials. So these materials, all their imported, they had number of godowns, 2-3 godowns, where these imported goods from Calcutta port dock used to be transported to those areas. And these merchandise used to be covered from the defendant under 2 policies. One is a marine cargo package policy, which is subject matter of this present suit. And the other policy is a standard fire insurance policy. Now, my lord, why I would like to explain why this suit and the merchandise and the claim involved herein are falling under the marine cargo policy is that as per the clause of the marine cargo policy, the merchandise, the cargo, after arrival at Calcutta port till their destination into the different warehouses were covered, including the stopover period. That is the stopover or rest during the transit.
That insurance policy.
The insurance policy. This is marine cargo package policy.
Correct.
So the entire transit from
unless it will reach to the cargo, this
to the distributors
office, distributor's location. So the transit and the storage during the transit was covered under this policy. And the storage period was covered for 8 weeks. But there are certain merchandises, certain volume of cargo, which used to stay back in a particular location beyond 8 weeks. Then automatically, those cargo stored beyond 8 weeks got covered under a separate fire insurance policy. So it is a location-based policy, two different policies, depending on the number of days the cargo is stationed there. So these are the two policies covering the entire merchandise, entire cargo of the plaintiff. While this policy was in force, the plaintiff hired another warehouse close to the Calcutta port in Garden Rich area. That is a very renowned and very old warehouse. That's name is Sale Tea House Warehouse. That was taken on rent by the plaintiff, and that was informed to the insurance company. And insurance company also issued an endorsement to the main policy covering that location as well. So that is Exhibit B. That policy and the endorsement, these are Exhibit B. Now, my lord, admittedly, this during the currency of this policy, on 6th January 2006, in early morning hours, a fire broke out in that warehouse, the insured location, Sale Tea House. The fire was noticed, and immediately police was informed, local police station was informed, and the fire brigade was also informed. The fire brigade came here. They carried out extensive firefighting operations, but the fire engulfed the entire warehouse. It took quite some time to subdue the fire. In the meantime, the entire merchandise of the plaintiff got absolutely damaged by fire as well as flame as well as heat. And whatever remained, whatever was not touched by fire or was not affected by heat, those were damaged in firefighting operation, because the firefighters entered, broke walls, entered the premises, sprayed water. So these are computer apparel. So once it comes in contact with water and moisture, that is damaged. That incident was on the same day reported to the insurance company. Insurance company appointed a surveyor, very reputed surveyor, JB Boda Surveyors Private Limited. JB Boda Surveyor conducted a preliminary survey, which is more commonly known as spot survey, recorded their initial findings, and then from time to time asked several documents. All these letters I have, correspondences I have exhibited. I'll go into that later, but they have the crux of the matter is whatever documents the surveyor asked from the plaintiff, those were supplied, documents and clarifications. But since the documents were sought in a piecemeal manner over intervals, I also supplied, my client also supplied those documents as and when they were sought for. After the documentation was complete, surveyor issued a report under two insurance policies. Under fire policy, they estimated the loss to the tune of around 1 crore. And under this marine cargo policy, which is subject matter of this suit, the loss was estimated at 1 crore 49 lakhs. Net assessed loss. After deduction of salvage, after deduction of policy excess, the net indemnifiable amount was quantified as 1 crore 49 lakhs. In the meantime, the my lord, the police authority carried out some investigation, the matter investigation, and they filed. They also involved the forensic department of the state. Forensic department issued a report to the police authorities, which were not disclosed to us. And the forensic department, from the police report and as submitted before the learned magistrate, it was found that according to the forensic department, there were presence of, it was a case of arson. It was a case of arson, and but nobody could be apprehended in this matter. So the case was closed there on the basis of that report filed by the police. Thereafter, the insurance company sought the plaintiff's comment regarding the observation in the forensic department's report that regarding the observation about arson. The plaintiff gave a reply to that query. Thereafter, the insurance company appointed and unilaterally appointed one investigator, a private investigator. Now the private...
Whether on the basis of the forensic report, the police has initiated any FIR?
No, my lord. No. It was a...
If it is not an FIR, how the forensic report has come in picture?
My lord, police had...
under which authority the police has taken the forensic report if there is no FIR?
My lord, no. State forensic was, my lord, that was appointed. I will have to check the documents, my lord. But this is the fact is that there was involvement of the state forensic department, FSL. So there was an FIR by FIR against unknown persons.
Correct. That's what I'm telling.
There was an FIR, my lord. There was a FIR. I'm sorry, my lord. So insurance company on its own appointed a private investigator. That investigator gave one report that was not initially shared with the plaintiff. Subsequently, on our RTI application by the plaintiff, it was shared with the plaintiff, but that was in subsequent stage. Now the forensic, as we found, that reading the forensic report by the private investigator appointed by the insurance company, it was a replication of what the state forensic department had said. It was a replication. There was no new finding, and that report was the private investigator's report was issued in 2006. In 2006 itself. Now from 2006 to 2012, the plaintiff continued to write letters.
When the private investigator was appointed?
In 2007. I'm sorry.
And when he filed the report?
My lord, he filed the report in 2007 itself.
Where your statement was recorded?
My lord, no, my lord. No, my lord.
He has not inspected the premises in...
My lord, that is not clear. That is not very clear from the report. The report is just a replication. It is, I will come to the report. It is copy-paste of the from passages of the state FSL, state forensic lab report. Now, my lord, investigator was appointed in 2007. By the middle of 2007, the report was with the insurance company. Now, my lord, from 2007 onwards, the plaintiff continued to write to the insurance company that you settle my claim, you decide my claim. And insurance company continued to, through the surveyor and sometimes on its own, continued to seek one after another documents which were already furnished to the insurance company in course of survey. And that too, this seeking further documents was going on after issuance of the final survey report. And I continued to supply all those documents again and again. This continued for quite some time. In 2012, insurance company issued a letter informing the plaintiff that they are appointing one investigator to investigate and assess the entire claim. And the choice of investigator was also unilateral by the insurance company, namely one Mr. J. Bashir and Associates Private Limited from Mumbai. Now, the plaintiff challenged that order. Plaintiff challenged that unilateral appointment. Plaintiff challenged that order of appointment of investigator on 2 counts by filing a writ petition before this honorable court. The first ground of challenge was that investigator cannot be unilaterally nominated by the insurance company. He has to be investigator has to be appointed through concurrence of Insurance Regulatory and Development Authority of India. Second ground of challenge was that investigator cannot be appointed for resurvey, de novo resurvey. The scope was too enlarged, so investigator cannot be permitted to conduct a resurvey. So there was initially a stay in that matter on that order. That matter was finally heard by my Lord Honorable Justice.
Yes, yes, no problem.
My Lord, that matter was heard. Now, an order was passed setting aside appointment of J. Bashir. But the other ground of challenge that was not allowed, that the scope of investigation should not be amounting to de novo survey or resurvey of the entire claim. So being aggrieved, partially aggrieved, the plaintiff had to challenge that order before the Honorable Division Bench. There were exchange of pleadings in a single bench, before the single bench, as well as before the Honorable Division Bench. Ultimately, this matter came up for hearing after several adjournments and some number of hearings. This matter came up for final hearing.
What has happened finally?
Final hearing, the learned counsel representing the insurance company gave a proposal, a very candid proposal before the Honorable Court, saying that this matter can be resolved by limiting the scope of investigation only to finding the root cause of fire and not entering into the other survey part, survey and assessment part. So plaintiff accepted that because that was their prayer all along. Then the Honorable Division Bench was pleased to pass an order that insurance company will obtain a nomination of investigator for this purpose from the IRDA within certain period, and the investigator so appointed was also directed to complete the investigation within a time-bound manner. Insurance company wrote to IRDA, and IRDA nominated another Class A surveyor, Mr. Falguni Purokasto, who is also a senior surveyor, as investigator to find out the cause of fire. Now, Mr. Falguni Purokasto issued a detailed report analyzing the cause of fire and also nature and extent of damage vis-a-vis the fire, cause of fire. So that report was issued, and that report was in favor of allowing the claim. That report was in favor of allowing the claim. Now, insurance company, after some time, after considering the report, proposed a settlement. Now, two things are very important here, my lord. Before I go to the settlement issue, I'll show the unfairness on the part of the insurance company in this matter, and action of the insurance company which is contrary to law, which is binding on the insurance company, all insurance companies rather. Now, my lord, in this matter, insurance company disregarded the expert opinion without taking a contra expert opinion. That is one part. Second is, my lord, all along, the contention of the insurance company has been arson. Now, my lord, so far I understand from the plain dictionary, meaning of the arson is setting fire on certain properties by somebody. Now, my lord, if your lordship looks into the policy, that is Exhibit B, it is all risk policy. Now, my lord, there is a peculiar character of all risk policy. In many insurance policies, in many property insurance policies, like fire policies, these are called named peril policies. Like 1, 2, 3, 4, 5, 6, like
Not covered.
perils are covered.
Good. Yeah, this is covered.
These are covered, and whichever is not mentioned as peril are not covered.
Not covered. That's right.
It is just the opposite in all risk policy. In all risk policy, everything is covered unless it is specifically excluded. Now, specific exclusion also contains, that is fraudulent claim. That is a fraudulent claim which in case of fire is like self-engineered fire. So arson per se, it is because of the forensic department said it is there's a possibility of arson. Insurance company kept on harping on that without appreciating that arson itself is a malicious damage. It is covered under all risk policy as well as in the fire policy. And what happened during the pendency of the suit? What happened? Some portion of the cargo was covered under the fire insurance policy. There is an arbitration clause under the fire insurance policy. The arbitration took place. There the plaintiff got their claim under the fire insurance policy.
Whose property was there?
On the same cause of action.
Correct. Whose property has been damaged?
My property, my lord. Plaintiff's property.
So who went to the arbitration?
Plaintiff went to arbitration.
So what remains here?
My lord.
So what is the claim here?
My lord, there are two policies. Premises is same. Say there is one cargo A and cargo B.
Correct.
Cargo A is covered under this policy. Cargo B is covered under a fire policy.
Okay. So with regard to the cargo policy, that is chapter is over.
Fire policy. Fire policy, that chapter is over. Plaintiff has won an award of the entire amount, I believe, 1 crore. And that is under challenge now under section 34. Now, after this, yes, self-same cause of action has been upheld in arbitration. It has been upheld in arbitration that the fire was an accidental fire. Whatever be the case, it is arson by somebody or it was any other accident, somebody threw a matchstick, whatever the cause may be. It was, there is no proof that it was engineered. There is no reason that it was engineered by the plaintiff. And there was no allegation also that plaintiff has engineered the fire. There is no allegation in the arbitration, neither in the repudiation letter. And so it is arson or whatever, claim is payable. Now, my lord, after the expert report, after the IRDA appointed investigators report was received, my lord, insurance company issued a letter. And from there, my cause of action arises. My lord, kindly, for once, look into paragraph number 31 of the plaint.
Okay, now with the facts come on the next day. 3 p.m. 3 p.m. matter hai? Counsel for the plaintiff has argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter appear on 26th August. 26.
My lord, can it be kept as part heard, my lord?
Yes.
But then could it be fixed at 2, my lord? I will not take much time in this matter, my lord.
Now 40 matters has been gone, and now your matter will come.
Either time or part.
My lord, kindly, my lord. Parted, my lord, your lordship has substantially heard here.
I will hear, no problem. Yes,
my lord, I have given a copy of the convenience brief to my learned friend also, my lord.
Convenience brief submitted by the plaintiff, we kept it the record. convenience brief, submitted by the plaintiff, be kept with the record. Yes. Who is appearing?
I appear. For the plaintiff. The examination in chief was ongoing.
For the plaintiff?
I'm the plaintiff. This was initially a non-commercial suit, also being heard undefended because the defendants had neither entered appearance nor filed written statement. Subsequently, my lord, we filed an application after Commercial Courts Act. It was transferred. At that stage, my lord, fortunately or unfortunately, they were given notice. They came up, filed their written statement. So now it is a contested suit.
So chief is going on.
Chief is going on. There were really just 3 documents which were marked for identification because these were electronic documents. There's an affidavit. I will just tender that. That is all.
But I was actually dumbstruck, my lord, for the 2 p.m. matter, my lord. Yeah, my chief, my lord, he comes and takes an adjournment.
That's why the advocate should. But I don't want to say
I
anything.
just couldn't say anything, my lord.
Yes. Where is your witness?
Yes, witness. And may I just file this additional judge's brief?
So when I was practicing, the seniors told me, before moving the court, please see the mind of the judge, then argue the matter or make the submission.
And not just that, my lord. My lord, this is what I've learned, that we should also see the order sheets. What is it fixed for?
That is always. Yes.
Well, just one thing, my lord, because of the transfer, initially we had filed a judge's brief. Now, my lord, after the plaint was amended to bring it in conformity with Commercial Courts Act, my lord, we have filed the Order 11 list of documents. One document that was, my lord, shown to the witness and he has given an answer marked for identification that was not included in the judge's brief. I am filing an additional judge's brief. I'll hand over a copy to my lord. Copy to additional. I've already given a copy.
Yes.
He is already on oath.
What is your name, sir?
My name is Ashish Kumar Mujumdar.
Ashish Kumar Mujumdar. Spelling? Ashish?
ISHIS. Mujumdar MAJUMDAR.
Defendant's letter. Huh?
IS. Only H. H is not there.
Mr. Mujumdar, I am showing you an affidavit. Please have a look at this and tell my lord what this document is. Additional judge কত নম্বর?
কোন অ্যাফিডেভিটটা দেখালি?
কপি দিচ্ছি।
কোনটা কপি দিয়ে দাও। হ্যাঁ, পেটি।
Yes, my lord. This is the affidavit which contains the electronic electronically.
This is an affidavit under section 65B of the Indian Evidence Act to prove the electronic document.
Yeah. Yes.
Who has prepared this affidavit?
This affidavit has been prepared by our advocate on the basis of the details that we have provided from computer and
the mails to take it down. Ask
on the basis of the details that I have provided
from our computer records and emails.
Does any signature appear on this affidavit?
Yes.
Can you identify the signature?
Yeah, one signature is mine, Ashish Kumar Mujumdar, and other is one commissioner.
Yes.
What do you have to say about the contents of this affidavit?
This is all correct and true.
Bank statement का दावा है ना ओरिजिनल
ये मैंने तो पिछला बार जो एग्जिबिट हुआ था डॉक्यूमेंट कौन था एग्जिबिट एक्स वाला आइडेंटिफिकेशन है
टोन exhibit T
दिखा दो
T for Telangana being PD 26 sorry PD 25 of the judge's brief of documents. Main registry. Page 96 of judge's brief. What a bhul hobe oটা PD 25 hobe page 96 right তো 25 তো এখানে তো ইন্ডেক্সে 25 এটাও 26 হ্যাঁ এটা 25 please come to the second paragraph appearing on the second page of this document, beginning with the words open inverted comma, however, comma, my client in good faith, dot, close inverted comma. Have you found that paragraph?
Yes.
Do you find the figures 1, 68, 42, 867? It's 97.
Yeah, I found the figure.
Yes, I find.
What?
Yes, next.
না কেটে দিন কোয়েশ্চনটা কি হলো shown so and so please just read that paragraph.
However, my client
to read it silently. Have you read that paragraph?
Yes.
It is the contention on behalf of the defendant that a sum of rupees 1,68,42,867 has been paid by the defendant to the plaintiff against the various invoices. Stop. What do you have to say about this? This is the contention of the defendant that they have paid this amount?
False and incorrect.
According to the plaintiff, what amount is due and payable against the various invoices? Can you say?
I have to look into because it's quite old data.
Shown the plaintiffs. May I just show the plaintiff?
Shown plaint.
Please come to the chart appearing at paragraph 31 at page 16 of the plaint. Stop. Can you say what these figures represent? Have you found page 16? There is a chart.
These are the amounts credited the bank entry, including the TDS amount deducted.
Now, can you answer the earlier question that was put to you as to what is the total amount paid by the defendant to the plaintiff?
Can you please repeat the question once again?
Now, can you answer the earlier question as to what is the total amount paid by the defendant to the plaintiff? Mr. Mujumdar, the question.
Have you understood the question?
Mr. Mujumdar, my lord is asking.
Have you
followed
understood the question what your advocate has asked for?
I'm trying to relate with the
question
figures.
is, what is the total amount that the defendant has paid? I have shown you this paragraph. There are certain figures appearing. Can you see these figures and give the answer?
1,68,32,747, including the TDS. 68 lakh
2,747.
It is the contention, it is the contention of the defendant that the goods and materials that were supplied by the plaintiff under the purchase orders suffered from defects which were not rectified by the plaintiff. What do you have to say about this?
That's false, incorrect.
It is also the contention of the defendants that the plaintiff has been paid in full for the goods supplied and the services rendered. What do you have to say about that?
False, incorrect.
It is the further contention of the defendants that no progress was made by the plaintiff in respect of the first work order, which is why the defendant was constrained to withdraw the same and issue a second work order. What do you have to say about this?
False and incorrect.
Please have a look at the plaint once again. Kindly come to pages 24. Please have a look at pages 24, 24 capital A and 25. So, can you say who has affirmed this plaint on behalf of the plaintiff?
If I get off.
It has been affirmed by Mr. Rajkumar Gandhi, who is the director of the plaintiff company.
What do you have to say about the contents of this plaint?
True and correct.
That's all. Well, may the affidavit be marked as an exhibit.
That is not. No, but the document which has been expert identification, that has to be confront.
Yes. Well, the document marked as X. Maybe shown.
This is to be confront. Then it will go as an exhibit.
Yes. Shown documents being PD 18, 19, and 20 of the judge's brief of documents. Please have a look at these documents and say what these documents are.
The same. So show the.
Those are different. Those are different.
Different.
Yes.
These are the annual tax statement under section 203 AA of Income Tax Act 1961, downloaded from the portal of Income Tax Department of Government of India.
Are these the originals?
No, these are the copies of the original which has been downloaded.
Which has been downloaded. Well, I think that suffices because the rest is there in my affidavit.
Put the question. Have you affirmed this 65 in connection with the document?
The affidavit that I have shown you earlier, has that been affirmed with respect to this document? Please have a look at the affidavit.
Yes. Affirmed.
This may be marked. This will be
Exhibit last के exhibit था.
V.
V.
V. V.
No. Wait.
Eta X. X1. Shown. Document being PD 22 of the judge's brief of document, email. Please have a look at this document and say what this document is.
This document contains the correspondences between Mr. Amit Agarwal, Director of MSP Steel, and Mr. Subrata Dasgupta, who is the engineering head, chief engineer, chief general manager in the engineering of the plaintiff company. Chief general manager, engineering of the plaintiff company.
What was the mode of exchange of these correspondence?
Email.
How have you obtained these emails?
The emails Mr. Dasgupta received, which was also given a copy to me. From that copy, copy was given to me, and from that copy, we have taken the prints from my computer.
Please once again have a look at the affidavit that you have filed today. Has this affidavit been filed also in relation to these emails?
Yes.
Let this may be
Exhibit W collectively. Yes, next.
That is all. Well, that is all.
That's all.
Can I ask a few questions and then the next step?
Cross.
Exhibit S ತಗೊಂಡೆ. Plain ತಗೊಂಡೆ.
Yes. Plenty fair.
PD not. Exhibit S.
Yes.
Exhibit S, shown Exhibit S and the plate. Mr. Witness, I suggest to you that the contention in Exhibit S, being a letter issued by your advocate, and the contents of the plate are contradictory to each other. Your advocate na kore plaintiff side.
I find the contents of this letter from our advocate true. And there is nothing wrong in this.
My question was that the statements made in this letter and the statements made in the...
It is my question that the contention made in the notice of the advocate is contradictory to the statement made in the plaint.
It's a suggestion. You may agree, you may disagree.
I disagree. I deny it.
So I take it that the contention in Exhibit S are true and correct?
Yes.
Akbar, Exhibit D tell. On Exhibit D. Mr. Witness, kindly tell my lord what was the scope of work under Exhibit D? So again, income yeah.
The scope of this scope of the work order is providing the engineering consultancy services for engineering consultancy services comprising design and engineering for civil, structural,
structural,
electrical instrumentation, etc. And
Instrumentation.
yeah,
And
etc.
etc.
required for 5 sets of each drawing.
Required for
Requires in 5 sets of each drawing. And upgradation of existing performance network. Upgradation of existing performance network. Supervision of modification, rectification at site.
supervision for modification.
Mr. Witness,
yes.
Mr. Witness, since the work order included submission of drawings, how were these drawings submitted to the defendant?
The engineering division of plaintiff department, they have submitted.
Engineering department of the plaintiff department has submitted.
Submitted the engineering drawings, design and manufacturing drawings in hard copy, the printed copies, as well as in the soft copies. Soft copies were mailed and hard copies were given to them.
Mr. Majumdar, have you disclosed the engineering drawings that you have just spoken about before this honorable court?
Yes.
Can you please point out from the documents as to which letter would indicate that you have submitted those drawings with the defendant?
Emails. The emails.
Plain judge's brief. May I frame this? Otherwise, it will take some time. May I frame this question? I suggest to you that you have not disclosed any document to show that the engineering drawings were submitted by the plaintiff with the defendant.
I object. Not the case in the written statement. That is not their case.
Within bracket.
I deny that.
The question objected by the question objected by learned counsel for the plaintiff as the same is not in the written statement.
May I continue on that?
That's all.
No, I'll continue. Lord, one request if I can make to my learned friend, my lord. Since we were a late entrant into this suit, my lord, he has given me all the documents, my lord, and he has also supplied me with the deposition, my lord. Only thing is, my lord, if he can give me the judge's brief of document which is not there.
We will.
They will give. Yes, record.
Step down and stay here.
Plaintiff is present. Examination chief started, and during his examination, kitna document exhibit hua? 2 documents were marked as exhibit V and W. Examination chief is concluded. Cross examination is started, but the counsel for the defendant has pressed for time to further cross examine the witness. Accordingly, cross is deferred. This is the matter on 28th October at
I will not be here till 31st October.
number dekho. Second number 6th November 3 p.m.
I hope it does not matter. That matter was today 2 p.m. This is 3 p.m. again. That is 2 p.m. on 6.
Yes, next.
Milord, 46, 47 and 48.
Yes.
I am for the plaintiff.
Yes.
These are, my lord, 3 undefended suits against the same defendant.
Correct.
Where, my lord, money was advanced.
Yeah.
In item 46, there are some part payments made. In 47 and 48, my lord, there are no payments whatsoever. May I, my lord, just hand over, my lord, the convenience chart one by one. Your lordship may kindly, my lord, consider decreeing. I have an ambitious prayer of 30% interest, my lord. But if your lordship wants me to recalculate that at a reasonable interest figure, I'll do that. And
30%, 13%.
330, my lord. It's an ambitious, my lord. Had your lordship, my lord,
have you got any 30% interest anywhere? Leave aside the India.
My lord, no, my lord. The pleading is so, my lord. The pleading is so, my lord. The draftsman, my lord, in his wisdom. My lord, I'll just run your lordship, my lord, through the.
It would be better you take the 100%, double of the amount, as per the negotiable instrument.
My lord, I will tell your lordship what is happening now. My lord, under the Arbitration Act, my lord, there's a schedule as per which the arbitrator has to be paid a fee, which is calculated, my lord, on a percentage of the claim. that, my lord, doesn't apply to your lordships. So, my lord, in arbitrations now, what is happening, my lord? Interest is always not more than
That
12.
is better. You give the proposal. The judges should be the schedule in the money suit.
My lord, just kindly consider, my lord, the note once. My lord, this is the amount paid. My lord, the dates are given. The first column, my lord, is the serial number.
The first suit, 77.
77, my lord.
Yes.
The second column, my lord, is the date. Third column, my lord, the payer, that's the plaintiff, paid to the defendant. And then, my lord, the amount. And the last column, my lord, is the relevant, my lord, entry in the bank statement, which was exhibited, my lord, in the judge's brief. That's the page number, my lord, in the judge's brief. I can give 2 or 3 examples, my lord, to your lordship. If your lordship just, my lord, takes the judge's brief for a moment, my lord, in 77. Beta judge's brief.
Hey, judge's brief. Yeah.
Kindly, my lord, consider the judge's brief. Page number 2. Volume 1. Judge's brief, volume 1. 77.
Yes.
My lord, kindly take page number 2.
Correct.
And my lord, kindly see the last entry there.
11/7.
11/7/2016, UK Traders.
Correct.
That is, my lord, the proprietorship firm of the defendant. UK Traders, 1,34,000 rupees.
Yes.
My lord, kindly see my note, my lord. There it shows, my lord, the details of the entry, and my lord, page number 2.
Yes.
Likewise, my lord, I am showing page number 3 as well. Kindly turn to page number 3, my lord. My lord, kindly see entry number 5 there. 2 UK Traders. My lord, same amount. My lord, it's in the chart. Likewise, my lord, it goes like this. So, my lord, this is the note. And then, my lord,
this document.
Yes, my lord.
This is your bank account statement.
Yes, my lord. This has been exhibited. Yes, my lord. This is issued by a bank. And, my lord, this has been marked, my lord, in the trial. My lord, as Exhibit A.
Exhibit A.
Exhibit A, yes.
Up till which document? Which page?
My
Total.
lord, up to page 47. Kindly, my lord, see my note. Kindly, my lord, see page. Kindly, my lord, see the last page of my note there.
Okay.
Those are, my lord, the list of exhibits which have been marked and I have described. Well, it's a convenience note for your lordship, my lord. Then, my lord, kindly, so, my lord, this is, my lord, part 1, the first table. Kindly see part 2 of my note. Second page, my lord. This is, my lord, the amount received.
Out of
amount received.
Yes.
Same way, my lord, entries in bank statements, my lord, I have shown.
Correct.
Just one, my lord, entry I would like to point out to your lordship. Kindly see, my lord, entry number 3 or 4. Entry number 4.
Wife of the defendant.
Wife of. So, my lord, some money he had paid from his wife. Because in one suit, some money that he has paid me, part of it has come from his wife. Same, my lord, number.
Okay.
So, my lord, this is, my lord, that entry at page 40. Your lordship may consider taking page 40 for a moment, my lord. Just one entry. My lord, kindly see at the first entry there, my lord, 10 lakhs at page 40.
Yes.
My lord, that is from the wife. So, I am adjusting that money to his advantage in this suit. 10 lakhs.
Okay.
And my lord, then kindly, my lord, turn over to the next page. My lord, the last page, just above the table, my lord, of exhibits. My lord, money advanced, my lord, is stated there. Amount repaid by
Total 124, out of which 71.
71 has been, my lord, yes.
So principal is 52.
52. And my lord, kindly also consider total due, including interest. My lord, 30% is, of course, I'm saying it's an ambitious prayer. From 11th July 2016 to 30th, to 30th November 2021, my lord, I have calculated the amount at 30% interest, my lord, as on November 30/31.
So from the first initial payment.
No, so my lord, kindly now see, kindly see the note there, page 8, para 13 of plaint.
Correct.
Kindly now take, my lord, para 13 of plaint. I have explained, my lord, how this calculation has been done. Plaint dena beta. Yeah. Your Lordship will see the table, my lord, there.
Yes.
My lord, principal I have specified, the total repayments I have specified, and then my lord, interest, my lord, kindly see it's been calculated, my lord, year by year. Now, my lord, this has been done at 30%. If your Lordship so desires, my lord, I can calculate it at another interest and hand over the same charge to your Lordship for the court's convenience.
So this principal sum paid 11 July 16 to 14 to 19.
Yes, my lord.
Correct. That is
Yes.
on 1,124.
Yes.
1 crore 24.
Yes. And my lord, part
So,
payments
but because if you go 124 comes only on 4th of February 2019.
Yes, my lord.
Correct.
Yes.
So the total amount of 124 was paid only on 4th of February.
Yes, the final installment. Correct.
Correct. The time final. So 124. So you will not get the 120 interest on 124 from 11th July.
My lord, so ideally, my lord, again, my lord, these are, my lord, based on the prayers and the pleadings in the plaint.
Leave aside the prayer and leave aside the pleading.
My lord, ideally how it ought to be, my lord, as and when, let's say, my lord, 10 rupees is given on a particular day, then another 10 rupees is given on the next day, 20 rupees. Then on the third day, if he's repaying 5 rupees, so on that day, the total amount, my lord, with interest minus, my lord, the principal. So, my lord, on that basis, my lord, which is why, my lord, I propose to give a Lordship, my lord, 3 revised charts. If your Lordship can, my lord, at least indicate a tentative interest rate, my lord, I can do the math at that, my lord, interest rate.
No, that is the problem. How you can calculate the interest? How you can calculate the interest? Because he has written the some amount.
Yes.
October, November, December.
Yes.
Correct.
Yes.
So last amount he has written on January 2019.
Yes, my lord.
He has written the amount on January 2019.
Yes.
7 January 2019. And last paid by you on 4th of February 2019.
So, my lord, as and when he has repaid, he should get advantage of that because the principal on which the interest is calculating will, my lord, reduce.
Correct.
Yes. So, my lord, for that, my lord, only in this suit, this is a problem because in the other two suits, there's no part payment. So, for this suit, my lord, if your Lordship can perhaps just indicate, my lord, your Lordship's mind, I will, my lord, recalculate the interest because, my lord, 30% calculation again will not serve the purpose because it's a very, very ambitious prayer.
Okay, then next.
Then, my lord, kindly consider, so, my lord, 77. My lord, kindly now take my lord, 78. This is my note. Similar note, my lord. Item 47.
Yes.
70. And my lord, 79, my lord. Similar note, my lord, in item.
So yeah, there is no return.
No, the only difference is here, my lord, it's simple. So there is no part payment in these other two matters. And my lord, if your Lordship recalls, there is one document which was marked, my lord, for identification, which I did not exhibit. Those, my lord, deeds to which I was not a party. Now, may I, my lord, indicate why I advise my client to just let go of that? Because it would have taken forever, my lord, to bring the registry and he's in need of money. It would have, my lord, money would have not, my lord, seen the light of day. My lord, kindly consider this.
Your case is that after they have received the amount from you, but they have sold the property to other.
No, my lord, that's not my case. My lord, it's a case of money advanced.
Correct.
For refund of money,
correct.
Money was not advanced, my lord, for purchase of property. Money was advanced as loan. Now, he had promised me that he is in the property business.
Correct.
He will use my money to invest in properties and that's how he'll get 30% returns. But in my prayer, I'm not claiming any interest on any of the properties that he may have, my lord, purchased.
The evidence which you have led that as per your evidence, though I have not allow you to exhibit this document, as per your evidence, the document, the plaintiff, the defendant has sold the property to other party instead of you. That's why you wanted to...
Yes, sales have been. But my lord, in my plaint, it's not
your case, money suit or performance?
Exactly, it's a money suit. It's not specific performance. Which is why, my lord, we've shown that we've given them money and they are to repay us. It's as simple. I'm not claiming any right, title or interest in the immovable property. So my lord, it wasn't required to be really proven. Otherwise, it would have unnecessarily, my lord, delayed the suit for another 2, 3, 4 years.
Okay.
So, my lord, 77, 78, 79. My lord, for 77, whatever, my lord, your Lordship considers, my lord, if your Lordship can indicate, my lord, some specific, my lord, I will then do, my lord, I'll hand over a chart with the calculation as per, my lord, how it ought to be.
See, I don't know what about the other courts. This court not calculating the interest in any of the degree till date. I have not calculated. This court is granting the principal amount with interest from this date to this date till the realization. That is to be calculated at the time of your execution.
Very
To avoid any complications in future. That's why this. So far as whatever the decree has passed with regard to the money claim, this court's principal is awarding with interest for certain percent.
I have seen your lordship's judgments for that.
Certain percent from the date the court will see when the last payment or whatever it is from the date till the realization.
Very
decretal.
Very so these are the three, my lord, charts, your lordship. And my lord, may I also just, my lord, point out that, my lord, in 78, it is 78 then, no, my lord. This is it, my lord. This is, my lord, it.
So 78, 77, 78, where is the 79?
78, 79, my lord. Kindly, my lord, kindly decree them, my lord.
Okay.
Seldom, my lord, do I move a matter for the plaintiff. Most lordship has seen me, my lord, appear for the defendants.
Counsel for the plaintiff concluded the argument. CAV.
Grateful.
All three, huh? 46, 47, 48. Yes.
He's done. One after the defendant. He's done.
Yes.
So I've taken out two applications for the rejection of the
plaintiff.
G6 and G7.
What has happened to your this, amendment?
That has been partly allowed, partly rejected. I have not challenged the order because we'll fight on that. But now that has gone to backstage because of this rejection of the plaintiff which I have taken out. GS6 GS6 but is relating to the 12A. My friend has taken out this suit, this commercial suit, and has applied for injunction showing urgency and sought dispensation of 12A. So now we have found and we have tried to place before your lordship
the GS6.
GS6 that 12A, no case has been made out, and in fact it is not in conformity with the provision 12A. So if it is not done, then the entire suit, as per the judgment of party, lordship knows very well, it has to be considered in that respect. And GS7 is that this is a very simple application. This is also rejection of the plaintiff because the suit was filed on 13 June 2024, but till date no steps have been taken for the issuance of summons. So this is another application which they will reply. GS7. So lordship will then please can you take up GS6 now?
So GS7 is not taking steps for requisites filing a writ of summons. That is, and this is the revocation of leave under clause 12, under section 12.
GS.
Yes.
Yes.
No.
Yes, continue.
You are right. But I'm not using affidavits.
Okay.
So for 6 and 7, I'm not using it. Rejection of plaint has to be on the plane.
It has to be rejected.
It has to be on the plane.
Has to be rejected.
No.
Lordship, the suit I have annexed in my application, it starts from page 19.
Yes.
GS6 देगा
GS6 কোনটা 7 করব না 6 করব বলো যেটা বল সেটাই করব 6 করব you like 6 so the plaint is from page 19
Now, Lordship, we kindly see the date of filing of the plate. It will appear on page 45.
13th June.
13 June 20. Just can you take the note?
Yes. Yes.
So, Lordship, may kindly see the prayer in the plate, page 40.
Yes.
The prayer begins from the very first prayer of my friend is that the plaintiffs pray for leave under Order 2, Rule 2 of the Code of Civil Procedure and prays for dispensation of pre-suit mediation under Section 12A.
Yes.
This is his prayer.
Yes.
Rest of the prayer, Lordship, A is declaration that the agreement dated such and such is an agency agreement wherein the relationship of plaintiff firm and defendant was that of a principal and agent.
So that is
these are the recovery positions, recovery of money.
Yes.
Permanent injunction, restraining the defendant from obtaining renewing any licenses. Permanent injunction, defendant from Tiswa kitchen, running Tiswa kitchen, mean profit, etc. Alternative damages, such and such. Now, this initially the first part of the prayer, dispensation. If you Lordship be kindly see paragraph 35 of the pleading, paragraph 35. The instant suit contemplates urgent, interim, and immediate relief.
Yes.
As stated above. Herein above, the ground of urgency are as stated above. The transaction between the parties are commercial in nature. The plaintiff therefore prays for leave under Section 12A of the Commercial Courts Act in as much as seeks dispensation of pre-suit mediation for instituting the institution. So therefore indicates as stated above. Now, Lordship may kindly see how this drafting starts. Lordship may kindly see.
35.
Now, Lordship may kindly see his pleading, paragraph 30, page 38.
Yes.
Procedural says the plaintiff is entitled to permanent injunction restraining the defendant from obtaining stroke renewing any licenses stroke permissions from municipal authority, statutory authorities showing the address of the Schedule A premises. The plaintiff is also entitled to permanent injunction restraining the defendants from using the same Tiswa kitchen and Calcutta Brew Cafe for running any business. The said businesses are all at all times operated as unit of Messrs. CNC, and the defendant cannot operate the same after expiry of the agency agreement. So this is his pleading of permanent injunction. So two things, Lordship, what I can gather is one is seeking restraining the defendant, so I will not apply for trade licenses, and also seeking restraining upon me that I should not run the business of Tiswa kitchen. Now these are all. The date of filing of the suit is 13 June 2024, which I have showed you, Lordship. Now this has been their injunction sought for, paragraph 30. Then see paragraph 31.
Yes.
The cause of action for the present suit arose from 30th July 2023. When the defendant failed and neglected to deliver the peaceful and vacant position of the suit premises to the plaintiff. The cause of action is
July
almost 1 year back, 11 months back.
Yes.
13 June. It starts from there. The Lordship will also see. Then he described the suit as a commercial suit. He says the contract agency, paragraph 33. because agent relationship. So there's a commercial transaction. So he's a commercial suit. So he tries to invoke the commercial jurisdiction, commercial court jurisdiction. Now, Lordship, we kindly see the schedule, which is on page 44. Schedule A and Schedule B.
Page
44 of my application. There's internal page 22 of the plaint.
Yes.
Schedule A, he described it as a shop commercial space measuring 1,700 square feet in total, 900 square feet on the ground floor and 800 square feet in the mezzanine floor, including internal staircase at premises number such and such. B, this is where he sought injunction. B, a portion of the Schedule A premises being an area of 250 square feet on the ground floor on the right hand side of the entrance to the kitchen and a toilet space such and such. And on the left, 400 to 450 square feet on the left hand side of the staircase in the mezzanine floor. This B, regarding B, if you see this prayer, there is no prayer for Schedule B. Because the prayer, Lordship, will see injunction starts from prayer D. D says not to renew licenses. E is injunction restraining the defendant from using the name Piswa's Kitchen. F is decree. G is alternatively any inquiry into damages for determination of mean profit, attachment, judgment, etc.
Yes.
So in the main suit, his case primarily prayer was that I'm talking about injunction. Regarding that, the licenses should not be issued to me. I will not go there. This is the main crux of the matter, and I will not use the name Tiswa Kitchen. These are two grounds which is seeking that I should be injuncted from that. And then he is seeking 12A. He is seeking dispensation because it's grave urgency. But if we, now I've read the entire plaint, the main relevant paragraph of plaint, you will find that as far as my understanding of law is concerned, he is not made out of any case of any urgency there. Now, if you see, one of the important things which is disclosed in paragraph 22 of his plaint.
(32).
22. Para 22, Lordship.
Yes.
Here, he, Lordship, I will use the word clever drafting. He has disclosed about the prior suit filed by me. Now, see his pleadings there. On or about March 2024, the plaintiffs were shocked to receive an order dated 27 February 2024 passed by this Honorable Court in FMET number 18 of 2024 along with cost papers of the appeal. So there was an order of status quo. According to his pleading, he comes to know in the month of March 2024. He files this suit on 13 June 2024.
Correct.
And the order he received is of the order date 27 February 2024.
Yes.
On perusal of the same, the plaintiff came to know that a defendant had filed a title suit TS number 2584 of 2023 against the plaintiff before the City Civil Court under false pretext and had endeavored to obtain order of ad interim injunction which the learned court was pleased to reject. The defendant had thereafter preferred an appeal from the said order of rejection and then obtained the order dated 27 February 2024. Thereby, an order of status quo over the suit site was granted till 6 April 2024. The said appeal is pending, and the plaintiffs are contesting the same. So, he had the knowledge, and there was an order of status quo of the suit property. So, his suit of 13 June 2024 showing urgency cannot sustain, Lordship. That is my first and foremost contention.
What was the interim order there?
Status quo.
With regard to the property.
Both the parties went in status quo. Regarding the property, business, everything.
Have you disclosed this in your application?
Now, I have Now, Lordship may kindly see my suit, which was filed earlier, is on page 83.
Page
83 of this application.
Yes.
Lordship, got it the plaint? This is the copy of the plaint. This was filed on 28th December 2023.
Yes.
Now it has been amended. Some amendments have done, but if you see the prayer on that day, when he was moving before this honorable court, my prayer was that this business of Tiswa kitchen is mine. That appears on page 102.
What is the date of filing of this?
The 28th December 2023, Lordship.
28.
20.
20. Yes. Decree declaring plaintiff is the lawful owner of the business.
Lordship.
Correct.
Now, my injunction was heard on same day. It was refused. Thereafter, we preferred an appeal before the Honorable Division Bench. It was filed on 17 January 2024. The appeal, Lordship will find.
So initially the interim order was not granted.
Not in sitting order, not granted. But when I preferred the appeal, this case was not there.
Correct.
So on 17 January 2024, I filed an appeal. The Honorable Division Bench passed an order of status quo, which is on page 265.
$265.
265.
Yes. Yes.
Now, copy was served. Now they have admitted in their plaint that in the month of March, they have not given the date. They came to know about this order of injunction and the matter has been filed there in the civil court. They appeared on 30th April 2024, page 266 in the High Court also. Next page, 266, Lordship.
Yes. Find it.
Then again, it was extended. Again, it was extended on 30 May 2024, page 267.
Yes. Yes.
Lordship, this was extended on 13th May. Thereafter, summer vacation intervened.
Yes.
We filed our extension application. Copy was served upon them, but the matter was not listed. Then finally, after mentioning the matter was again listed and was taken up for hearing on 8 July 2024. That is page 270.
270?
270.
Yes.
This order is dated 8 July 2024.
Yes.
Here, if your Lordship see the learned counsel for the respondent submit that he shall be filing an affidavit opposition to bring and record certain events in the interregnum. Is 6 week accommodation, find the same. So this is of 8 July. Now, in between this period, he comes before
This suit was filed.
He comes before this honorable court and file this commercial suit on 13 June 2024.
Yes. Yes.
Now, Lordship knows the provision of section 12 here, Lordship, to make cases, Lordship, during everyday Lordship. So, here the thing is that in order to bypass or scuttle, he has to come with the pleading in this plaint that why he is seeking dispensation. In the injunction application, he has come with that there is the urgency. Now, his injunction application, if you see in page 50, his injunction starts. He makes a ground that his prayer is that I am trying to create third party interest. Kindly see page 31.
Yes.
His first prayer.
31.
Page 71 of, sorry. I'm so sorry. Page 71 of the injunction application.
Yes.
He is seeking injunction against me. This is again, it was filed on 13 June 2024. He is well aware there is an order of status quo by both the party. He is contesting there. No, see his prayer. An order of temporary injunction restraining the defendant, respondent from creating third party rights, interests, or encumbering or dealing with or parting with the position of the Schedule A premises in any manner whatsoever.
Yes.
How could he make this? Put the question to myself. Despite knowing that in my appeal, I have taken the order of status quo.
Yes.
B is also akin prayer. An order of injunction be passed restraining the respondent from using or utilizing any area beyond the restricted space as detailed in Schedule B. So this B is that B 400 square feet is shown in the plaint. The original prayer is not there. He is seeking temporary injunction when there is no pleading or no prayer made in the original suit as a permanent injunction. These are all the consequential prayer is there, but he has not even, this is also so vague. Outer space, extra space, anyway, I'm not on that, Lordship. My question, my only thing is that, Lordship, this prayer in itself is in contrast and in contradiction with the order passed by the Honorable High Court status quo, Lordship.
Okay.
And he was well aware. On 13 June, is filing this injunction application, Lordship, with the reason based on to why he has made this prayer. He had the knowledge that suit is pending in the civil court. Now, where is the urgency, Lordship? I'm putting the question to myself.
Okay.
And where is that pleading, Lordship? Lordship, I've got some judgments also on that point because the court, apart from 22 Supreme Court, in several of the cases have been held that one has to see what are the pleadings in the plaint in order to sum up and to find out where is the urgency, Lordship. I have shown you some paragraph, Lordship, of the entire plaint. In none of the paragraph, or as far as my reading of the plaint is concerned, he has made out any case of urgency. And that also when my suit was pending there and that order of status quo there. So only on that I will give you this judgment, Lordship, for the sake of a reference, Lordship.
Which one? Which judgment you are relying upon? Yamni Manu or Dhanbad Fuels?
Those two judgments are there, Lordship. That is a celebrated judgment, Lordship. But even some of the High Court has also.
Our High Court is Gabriel.
In some of the High Court has also affirmed the judgment and said that only one thing the court has to look into the pleadings. Lordship knows this is settled law, Lordship. So I'll just refer it. Lordship knows all this. This is the initial judgment, Lordship. So Lordship has heard several times, Lordship. I will not waste time just for the sake of.
Lakshmi Polymer. That is the first judgment.
This is the what is the Patil.
Lakshmi Polymer was the first.
Here, is correct.
Lakshmi Polymer was the first judgment. Then Patil Automobiles come. Thereafter Yamni Manu.
Yeah,
then
these are all the same.
Dhanbad.
Then Dhanbad is there.
Finished by Dhanbad.
Finished by Dhanbad.
You can't say finished. We don't know what will happen.
Again,
There's the three judge, I believe.
No.
That's right.
Dhanbad is two.
Bombay Supreme Court का pattern दो ना ये pattern judgment ऐसा copy कहाँ है? Where is the copy of this? Lordship, one minute, Lordship.
Yes.
Lordship, pardon me because my junior is written with the pen there. This party lordship.
Yes.
The guidelines have been framed. Supreme Court has decided that it is mandatory from paragraph 99 onwards, lordship. Because this 12A was inserted in 2018.
Yes.
धन्यवाद. Dhanbad is also the final judgment, but I will give you some High Court judgment also, lordship, because that I find so. New Delhi, na? So this Dhanbad have given to my lord. Lord, Dhanbad is from paragraph 239. So many paragraph which has dealt with prospective and retrospective. 2018 before suit, lordship knows that. This is Delhi High Court, lordship. Note for time नहीं है हमारे पास. Time नहीं. Bombay का तो. This one is Bombay. All approved in Yamni.
Yes. Yamni Manohar has been taken.
And this Himachal is 2024. Paragraph 28. Strictly said. 17 to 28 lordship Himachal. All the courts, what I find, lordship, emphasis on the statement and object of the provision of section 12. That has been described in a detail, lordship. Thereafter, the court has come with the conclusion that it is mandatory. If not done, or if a clever drafting is there to scuttle or to subterfuge or bypass, or then the court has to take a strict view and to decide. So these are my some substantial, lordship.
Thank you.
Grateful.
Thank you.
Yes. You're wasting time.
This is GA6, which we are hearing, the revocation of these the prayers before your lordship. It is humbly in the premises. Your lordship will be graciously pleased to reject the plaint under Order 7 Rule 11 of the court for violating the mandate as enumerated under Section 12A of the Commercial Codes Act. So this is the prayer before your lordship today. Now, the question arises, two questions, my lord. It is a commercial suit, whether I have gone for mediation or I have asked for dispensation. And if dispensation, and here I have gone for dispensation, if dispensation is there, what is my pleading? Now, one order, this order must be at 18th of June 2024 in the bunch of orders. But this was passed in the suit. If the bunch of orders is there, there's the first order in the suit. It is not annexed.
Yes, 18 June.
Yes. Counsel for the plaintiff has filed the suit against the defendant for declaration of the agreement such and such. Agency agreement wherein the relationship of the plaintiff firm and the defendant is the principal agent respectively. The plaintiff also paid for decree for recovery of possession, cause possession from the suit. Counsel for the plaintiff has filed the present application without invoking pre-mediation process and has prayed for urgent relief. Accordingly, this court finds that the plaintiff has prayed for urgent relief and also filed an application for grant of interim relief. Leave under Section 12A as well as Order to Rule 2 is granted, subject to scrutiny. Today, there is no application. Whether appeal can be preferred, I am not sure, it may not be, or recalling of this order, or for revocation of the leave given to me. There is no such application before Lordship. The application comes under Order 7, Note 11 for rejection of the plaint. So this order is there, which order Lordship was satisfied and granted me the leave. Now this leave was granted based on the pleading in the plaint. Now if we look into the plaint, my lord, which is page 23 of this application, my learned friend has read paragraph 30.
No, that's all the things is there. One question has been raised by the other side. You, in paragraph 35, you have raised the urgency.
Paragraph 34, 35.
34, 35,
Paragraph 34,
you raised the
35.
urgency, this court has considered.
Yes.
And along with your application, and you move the urgency application, the court has granted interim order. Now, the other side has raised the issue. You had appeared before the appellate court where you had the knowledge with regard to the status quo order.
Yes.
Correct. If you had an knowledge with regard to the interim order passed by the appellate court and the appeal was going on. So, and status quo order, so what was the urgency?
What was the urgency?
The urgency. Once there is an status quo order, you can take an, if they are violating the order, you had the right because you are the
yes.
You are there.
Now the question arises whether, so these are on the pleading in the petition. Now, in support of this, Lordship will also come to my pleading, which is paragraph 22. Whether this proceeding before the City Civil Court and the appeal before the Honorable High Court, the FMAT, was suppressed by me or not?
Not suppressed.
There was no order.
No.
They
have also not taken the plea with regard to
suppression.
Here only with regard to the 12A. 12A, now the...
On the date when...
Now the law is settled, 12A, the court has to see the pleadings, cause of action, the prayer, and urgent relief is urgently required. If the party will go to the mediation, your purpose should be
frustrated. Yes.
These four things is to be taken.
That is paragraph 61 of Dhanbad Fuel.
Yes.
The conclusion portion.
Clause F.
Clause F. Paragraph 61 of Dhanbad.
Clause F.
Test of urgent relief. This says is seen from the standpoint of the plaintiff. Yes. This is the change from Patil.
That's it.
Patil was the court should also look into.
Even our High Court in the division bench, Gabriel, and subsequently the other division bench has considered. So the court has to see, and the urgency, the plaintiff, it might be the cause of action arose 2 years before. But today, when you moved that application, it found that you cannot wait for the 3 months.
I cannot wait for 3 months.
Or 7 months.
It will get frustrated.
That's why the court can grant
me.
Correct. That is
yes.
And this court grants if it is found if urgency. Now here what prompted you, or rather the plaintiff, if you are having the status quo order.
The order was not there.
That's
yes, I'll just show. Now Lordship will see my pleading and the order. I'll show. The day the order was passed, my lord, the order was passed, the status quo order was not there. And that is recorded in my lord's order.
Kindly come to
first, Lordship will kindly see paragraph 22 of my pleading. Page 34, which is in this GA6.
City Civil Court and order.
Yes, was shocked. Yes, handed over. Now, the defendant there preferred an appeal. They have an order of status quo. The suit was granted till 6th of April.
Correct.
The said appeal is pending and the plaintiffs are contesting.
Yes.
The contents of the plaintiff. The ad interim order was extended till 27 May by an order of 13 May.
Yes.
Now, this is the extension till 27 May.
Correct. First order is 27th of February.
Yes.
265.
Up to 66th April.
Correct. Now, 265 is the first order of the division bench.
265.
Till 6th April 20, over the suit till 6th April 2024.
Yes. This order was passed till
6th of April
6th April.
Correct.
Yes.
Then thereafter extended till the next date of hearing on 266.
Then it is 13th May. The interim order. Just
till the next date of hearing. So 30th April.
Yes.
6th April.
Yes.
The interim order was 6th April.
Then is 13th May.
Then no. Then kindly come to on 30th, 266, 30 April.
266, 30th April.
30th April is the
till the next date of hearing.
Interim next date of hearing.
My lord.
30th April it was extended. Then it come on 13th May.
My lord.
13th May. In the meantime, they have filed an application for extension.
Yes.
The court is of the view that before the expiry of the interim order, the application was there.
Yes.
The
Now-
court has extended.
No, Lordship, timeline.
Yes.
In
the
view of the
filed
urgent determination, as you will see,
Hmm.
no material change between the interim order. The interim order passed earlier shall continue for a period of 2 weeks
Hmm.
or until further order.
2 weeks or until further
Yes, so
order.
this interim order
Ah.
expired on the end of June, end of May. And this was not extended. And Lordship will kindly mark here, I moved this application and I got the interim order on 24th of June.
Hmm.
So this interim order expired on 30th of May. Now the next page, my lord. Next is, now we come to 70 is at 8th of July. And the interim order, the ad interim order of injunction passed by the commercial court, kindly mark is on 24th of June 2024. And my lord's order specifically records this. I'll just come.
So 13th May, 2 weeks.
Yes, that takes us to end of May or 29th or whatever, 29th or
And thereafter
28th.
it was not extended. Yes.
And this is recorded in my lord. Lordship will now see 24th June order passed in the injunction application. That will be in my lord's. After, I'm only on that portion. Yes. Lordship will see page 2 of my lord's order of 24th of June.
Page 2 of
24th June order. We can in the bunch. That's the second order. I obtained the 12-day leave on 18th of June. And then this is on 24th of June.
Yes.
Now, last line, if you go to page 2, then the paragraphs numbers were not there in that one.
Yes.
Yes. The defendant has filed an interim order learned city civil court was refused. The defendant preferred an appeal. The appeal is pending before the division bench. Initially, on the prayer of the defendant, the appellant court has passed order of injunction directing the parties to maintain status quo. Subsequent interim order extended 13 May, which I showed to your lordship.
Yes.
For a further period of 2 weeks. And thereafter, the interim order has not been extended, but the appeal is pending. And this appeal got extended, what I showed to your lordship, that page 268. When it was got extended to 268 is the hell. No, not 268. Sorry. This got extended 270. 8th of July. 8th of July. Everything was stated, and this is the fact.
Yes.
8th of July. And now what happened? Now this is another twist, my lord. This was extended. Now the question today we are nearly 1 year thereafter. Now lordship will kindly turn over the page. Lordship is at page 270. That is slowly.
Yes.
Lordship is at page 270.
Yes.
This interim order, this my lord's order was in June. That interim order was extended in 8th of July.
Yeah.
Now, lordship will, the question which I'll answer, then what happened? This is the answer to what fell from your lordship, whether the order was subsisting or not. So my submission was the day the order was applied is recorded. The interim order expired. It was extended much later. So I could not on 24th of July forecasted or thought what will happen 7 days even tomorrow. Now what happened? Lordship will kindly come to page 272. Page 272 is the final order disposing of the appeal.
Yes.
And that interim order was not extended because of my lord's order. Thereafter, now lordship will place this order, page 272. The court, page 270. Yes. I'll just read, man. Heard the counsel for the appellant as well as the respondent. The parties have made submissions with reference to the order of 21st of December, whereby the prayer for ad interim injunction as the city court matter. The court is informed that the respondents have also filed a suit for eviction of the present appellant in the premises in question, wherein, after due consideration of the issue, an ad interim order of injunction passed by the High Court exercising original jurisdiction on 24th of June. My Lord's order, the portion is quoted. The ad interim injunction dated 26th of June quoted above has been passed against the present appellant. As per the same, the present appellants have been restrained from creating third-party interest or dealing with the property with any third party. They have also restrained the using the conference room. Insofar as the alleged threat of apprehension of dispossession of the other portions of property is concerned, we find that the apprehension for the moment has been taken care of by the above quoted order dated 24th of June. In view of the nature of ad interim order passed against the present appellant, since no threat of disposition arises at the moment, subject to final orders being passed, we consider it is appropriate to parties to relegate to the trial court. At this juncture, the learned counsel for the respondent submits that we will file those are for reply to the injunction application which we sought. The court could only record the trial court expedite whatever. So the ad interim order, whatever was passed, was not extended later in view of my Lord's order. And this continued. Today, before the City Civil Court, this my Lord's order is in force. Because of this order, and so the Honorable Division Bench also passed this order based on the order passed in the Commercial Division.
Yes.
So today first of all, the day on 24th of June, the ad interim order passed in the appeal was not subsisting. This is number one argument. Number two, my Lord, I have necessary pleadings, urgency which I have sought in my plaint, based on which my Lord was satisfied and granted me the clause 12 leave. There is no application for revocation of clause 12 leave. The application which is coming for rejection of plaint under Order 7, Rule 11, that could not have been a rejection of plaint on this count, my Lord. And fourth is, my Lord's order of injunction was affirmed. I shouldn't use the word affirmed because not the same proceeding, but any event was noted by a division bench of this court in a proceeding with the same parties with approval. And this interim order is continuing till date. Now, and last thing is, my Lord, so far, Dhanbad Fuel, what my Lord has said, that it is from the viewpoint of the plaintiff. Because the earlier view was the court will also see independently, but Dhanbad Fuel is the last order from the viewpoint of the plaintiff. So this is my answer to the rejection of plaint, which is GS6. Now, so that I'll say the GS6, I'm not using affidavit because this point, should be dismissed. Now, when I'm getting the timer, so far the other application is concerned, which is because I know my inventor not pressed this, the smaller one, which is GS7. GS7, though I know she has not opened it. GS7 is an application for once again dismissal for non-service of writ of summons. Now, here, my Lord, there is a problem in the department on scrutiny. So, my GA5 is there. It is only after my GA5 is served, GA7 comes in.
When the scrutiny is completed.
No, I'll tell you, Lordship. GA5 to the আমার ব্রিফটা কোথায় না না ঠিক আছে দাদা GA5 টা কোথায় দাদা the GA5 my Lord, she will take, there is one amendment is required, but she will kindly GA5 টা দাও না
GA5 I think he has not argued. I am not deciding that.
What happened, my Lord, the amendment is so innocuous. After that, there are three plaintiffs. So plaintiff 1, plaintiff 2, plaintiff 3. So it has gone after the three names. So it has gone in defendant 2, 3 and 4 are partners. So it should be the plaintiffs are partners. That is the only difficulty and we have missed out. So that the defendant should be plaintiff. That is the, so, and by any means, after he obtained the ad interim order, compliance of Rule 3A, everything has been served. The injunction and the plaint. Those has been served. Along with because my affidavit of service records that. the injunction along with the plea.
So 6 is complete.
No, Lordship. Reply. I'll give a reply to him. He has what I understand. Digress from the issue of the urgency and 12A. He went for the order and I'll show it. I have not
answer
to. I would like to argue on
the interim order is till 22nd of this month. So that.
So GS6 Lordship, then kindly keep it tomorrow or day after tomorrow, because I'll just clarify the thing which is trying to say that there was no interim order.
Learned counsel for the defendant has concluded his argument in connection with GS6 of 2025. Counsel for the plaintiff and the defendant concluded.